Welcome to the Friday morning session of what's been a fantastic event so far. I'm Catherine Easton and I'm here to chair panel 3. So we're looking at an in-depth discussion on AI accountability and decision making. As with the other sessions, there is an opportunity to pose questions to the panelists through the Q&A function. But then there's also a chat function for comments. Now this can be saved and put to the speakers later. So you can put comments in the chat and there's a Q&A function for you to pose questions. But then also remember the event that we have later on at 4:30 at the end of the formal part of the conference when you can meet the speakers and it can be perhaps more interactive then. Okay, so we have a wide range of speakers who are going to address the issues, and then at the end we have Prof. Ian Walden, who will be the discussant on this session. Excellent. All right, so Monica unfortunately can't be with us today, so our first speaker will be Özlem. So please could you take to the virtual floor. Thank you very much.
Thank you, Catherine. I'm hoping you're able to see my screen here.
At the minute we can't.
Okay, let me, can you see the screen now? Great, thank you. Okay, good morning to all. Thank you very much for the kind introduction to Catherine. I'd like to set out what I've developed and described as the human-centric and life cycle approach to AIS systems, so autonomous intelligent systems in general, but in particular looking at legal responsibility. So, to start off with, sorry, my screen is freezing at the moment, so let me just... For some reason, I'm not able to move to the next slide. Can somebody advise on that, please? Okay, I will close. I'm afraid it's not allowing me to move to the next slide, so let me just... Okay, there should be a change in the slide at this point. Catherine, can you just confirm that's the case, please? Yes, thank you very much. Okay, so starting with the problem of unintended consequences. In 2018, whilst I was working as a technical expert to develop international standards on AIS, I came across a software programming ontology, WordNet Synsets, which referred to the concept of obligation through the hyponym of, quote, the white man's burden. Now, Rudyard Kipling coined this phrase in his 1899 poem, The White Man's Burden, the United States and the Philippine Islands, encouraging the United States to assume colonial control over the Filipino people and their country. Now, the phrase is associated with racial prejudice and justifies colonial exploitation, and corresponds with Kipling's belief about the role of the British Empire at the time. What was such an outdated and offensive phrase doing in the software programming ontology? And what is the legal responsibility of software programmers and systems designers when relying on flawed design phase premises which lead to unintended consequences? So this probed me to think about this more carefully and consider whether it's a pervasive problem throughout the ontologies and indeed programming. If we think of the essence of obligation as present in legal systems, cultures, and religions, this can be expressed in neutral terms as follows: an act or omission required of someone under national, regional, or international laws, cultural or religious norms, and or codes of conduct, and if not fulfilled, would lead to some sort of sanction, whether liability and punishment under the law, or shame, ostracization, and exclusion in cultural and religious contexts. Yet the WordNet Synset's classification of obligation as the white man's burden illustrates the potential for programming bias to creep into systems design and development through use of outdated, culturally insensitive and ethnocentric terms. From this perspective, the prejudicial and exploitative connotations are carried over into crude algorithmic design in the AI-based system, so that it interprets obligation as meaning an imposition of will rather than relational or context specific. This can cause coercive behavior in the system to persuade or restrain a human agent by threat of mental or physical pressure or actual pressure. So an example would be, if you don't do X, you may suffer Y, or if you don't do X, you will be entitled to Y. The system may also be able to manipulate a human agent's thoughts to distort their freedom of expression, beliefs, and actions, or participation in political processes and voting rights. As for the legal concept of responsibility, this determines who or what will be held liable for any harm, damage caused by the technology. AI has the potential to disrupt the attribution and causation chains unless there is always a human who will be held responsible throughout the AI design, development, and deployment stages. Self-learning algorithms and robots present the spectre of harmful and unattributable behaviors, which at the same time undermine human agency of foresight, prudence, and judgment in taking action with consequences in mind. Now, although responsibility is a priority ethical value and legal requirement contained in several global, regional, and national regulatory frameworks, its interpretation and implementation differs. I want to give some examples here. In the UK, there is recognition of legal responsibility, accountability, and legal liability as key issues in the application of the law to AI. But it focuses on developing principles of accountability and intelligibility, which are not the same as legal responsibility or liability, with the possible of a review to the adequacy of existing legislation and legal liability. And this is mainly from the House of Lords report. Now, this actually conflates legal responsibility with accountability, and therefore weakens the sense of any liability that may be attributable to a person for the harm or damage caused by the AIS. Accountability may simply require explaining and accounting for conduct or action without suffering any legal consequence or sanction. Whereas legal responsibility as duty-bound and with sanctioning element differs. By avoiding the identification of responsibility, it enables various actors to engage in unhindered and unregulated design, development, and deployment of emerging technologies, even when the law may be ahead of the technology and having the foresight to set boundaries and responsibility limits. The conflation approach ensures this does not take place. Another example is the dispersal approach, and this is to scatter responsibility across several sectors, individuals, or institutional structures, making it harder to understand and attribute, and indeed for claimants to work through the liability maze to seek justice. An active way in which responsibility may be undermined is also to dilute its meaning and effect by, for example, restricting the areas for which a person will be held responsible, by explicitly excluding liability, or limiting the types of liability. Now, an example of the dispersal and the dilution approach is seen in China, and the representation of responsibility at the moment as it's been formulated in China. Although responsibility is seen as a core principle applicable to both the AI development and deployment stages, it is situated within an ethical framework biased towards commercial exploitation for the purpose of domestic economic growth. So in that approach, it becomes unclear who or what will be held legally responsible, and future policies or laws may contain a commercial intellectual property or trade secrets exemption, preventing disclosure of algorithmic models, data sets, and algorithmic reasoning. Thus, in order to mitigate against unintended consequences and problems in representation of legal responsibility, I propose adopting a human-centric, what I call a human-centric and life cycle approach to the design and development phases of systems. Now, I'm hoping I'm able to share with you the next screen, but I may not be, so I'm just going to pause and then okay, hopefully that should be the screen. Yes, thank you. Apologies for the slight delay here. Now, I've argued previously that a technology-biased approach to regulation of AI that focuses on AI capabilities and limitations to improve performance, optimize operational efficiency, and identify and rectify any errors or failures actually creates legal and ethical dissonance by not aligning design, development, and deployment with the values that protect the human user. So the technology-biased approach, in my opinion, is deficient. The human wants, needs, and desires, desires, and values, as I categorize them in a bundle, should be incorporated in the AI system design, development, and deployment in order to maintain human autonomy and responsibility. Now, what does this mean? The human-centric and life cycle approach involves prioritizing human wants, needs, and values through user awareness, protecting human rights, and recognizing non-deterministic influences on decision-making, and then applying these throughout the life cycle of the system. And that means from the design, development, manufacture, deployment, and post-deployment phases. This will then elicit a spectrum of individuals or entities who can be attributed with legal responsibility. Now, breaking these down, again, I will have to pause this and come back in.
It works. It does work.
Oh, it's working. Great.
Yeah.
Okay. I'll just come back in. So you should be able to see the screen user awareness. Yeah, okay. So taking these components individually, with user awareness, the AI designers and developers would need to think about how to achieve the user awareness of the system's purpose and capabilities. And this can be broken down into 3 stages: the pre-use stage, the during-use stage, and the post-use stage. The pre-use stage, the human user should be aware that the AIS is in full or partial operation and be able to consent or opt out of such an operation. During use, the user should be able to maintain an understanding of the system's purpose and capabilities, as well as have the opportunity to opt out. Now, this becomes particularly important and relevant where there is a black box scenario, making it difficult for the user or programmer to understand exactly what the system is doing and why. In the post-use stage, users should be aware of how their data and information shared with the system will be used either by the system or third parties, and be provided with redress mechanisms for any errors and harm that can be caused. The next component, which is the protection of rights, this is quite a broad area, but I do break this down into more detail in the paper. It's the AI designers and developers who would need to take account of rights to privacy, data protection, and fundamental rights. So the privacy and data protection rights I draw from the GDPR and Convention 108 Plus, because they're the obvious starting point in terms of addressing the entire life cycle of the system. These rights relate to not being subjected to automated decision-making, prior consent, prior notification of the right to withdraw consent, notification of automated decision-making, access to personal data, access to information on the logic of an automated decision, information on the significance and envisaged consequences of automated decision-making, objection to processing of data, lawful, fair, and transparent processing of data, and rectification of any problems. Among the fundamental rights most relevant for an AI system or AIS system would be respect for freedom from torture, cruel, inhumane, or degrading treatment, freedom of expression, freedom of thought, conscience, and religion, and freedom of association. Now, I want to give a few examples because there are various domains in which AIS can be deployed and which can represent the fundamental right or not. In my work on the use of autonomous weapons in warfare, I've argued that such weapon systems are contrary to human dignity because they actually constitute a form of cruel, inhuman, or degrading treatment because they treat humans as disposable, inanimate objects rather than ends with intrinsic value and rational capacity. I won't go into any further detail on that because time's limited, but it's very well developed in a separate paper. The second example is if a system is able to manipulate a human agent's thoughts so as to distort their freedom of expression, beliefs, and actions, this would not represent rights of freedom of expression, thought, conscience, and religion. This is alluded to in the EU's AI guidelines, and this could impact on the participation in political processes or voting rights. Now, this year, the UN and the OSCE and the OAS have issued a joint declaration of freedom of expression and elections in the digital age. And they note the alarming rate of misuse of social media by state and private actors to subvert election processes. And the recommendation itself provides for state obligations to provide a regulatory environment and infrastructure to promote free access to information, media. It also provides for non-state actors to assume responsibilities in their digital media platforms and taking reasonable effort to adopt measures that make it possible for users to access diverse political views and perspectives. So those are two examples, and I want to just finalize now on the third element of the human-centric and the life cycle approach, which is the non-deterministic influences on decision-making. Machines and algorithms can engage in practical reasoning, i.e. what to do, and at great speed, working well within pre-programmed premises and assumptions. But they are restricted to binary input and output, yes, no, true, false, and cannot engage in pure reasoning. And that pure reasoning is mulling over or pondering in abstract form, where there is no definitive answer, And the problem requires whimsical, inconsequential reasoning, inconclusive reasoning that may resurface at a later stage to enable actual decision-making. Thus, acting on practical reasoning, the machine may be able to produce statements such as, AI is a new innovation that will lead to new challenges. Yet the AI is incapable of engaging in critical and reflective thinking around that statement, and as to what these AI challenges might be and how to mitigate them. So recognizing non-deterministic influences on decision-making could mean that prior to deployment and regulation of AI, rationale needs to be provided for context and appropriateness of use, taking account of non-deterministic influences. Policymakers, legislators, the regulators should consider what is legally and morally acceptable and therefore bear responsibility for their actions. AI designers and developers would need to consider whether it is possible to represent non-deterministic influences on decision-making in the system. And if it is not, then users should be notified of the system's deterministic nature and be able to opt out. Another example of isolating this is to say that the human capability of pure reasoning should be ring-fenced, and those scenarios or context which require that pure reasoning should be left to human ability and human capability and direct human responsibility. And on that note, I'd like to end and thank you for your time.
Thank you so much there for such a fascinating paper. Questions have been raised that perhaps we could talk about later about the practicalities of getting change in these environments that are really quite slow moving. But before we get on to things such as that, I'd like to move on to Soren's paper, please. Could you please take the virtual floor? Thank you.
Thank you very much. Okay. I'll be talking about transparency and contestability in AI-supported judicial decision-making. This is work I'm doing with my colleague Thomas Flo at Algo University in Denmark. Now, sort of the background assumptions we make for this particular paper is that it's generally accepted that judicial decision-making has to be transparent and explainable to those who are affected by the decisions. And of course, we can have long discussions about what transparent and explainable might mean. It's also generally accepted that decision-making and decision support by artificial intelligence has to be explainable. And it's reflected in many places, including in the GDPR. But there are different accounts of how we should explicate the concept of explainability. And because we have different accounts of what explainable means, we also end up with different accounts of the practical consequences of this requirement. What does it mean in practice that an AI system should be explainable? And this raises problems because the current best AI architectures are explainable in one sense. They are algorithmically explainable. We can go through the algorithm and say exactly why a certain outcome occurred. But that's not a type of explainability which explains to a human being how that decision was actually made. So they are, in a certain sense, black boxes where we can't fully understand the decision making. So what we want to consider is a particular scenario where we have AI support for sentencing decisions. I think again, it's generally recognized that the sentencing guidelines for England and Wales are rather complex, and that they are not always appropriately applied. So AI support for magistrates and crown court judges could plausibly increase consistency in sentencing and therefore be a good thing. Now we could build a system which we'll call jail time E and W, trademarked of course, which would provide sentencing advice in terms of a suggested sentence and a list of the sentencing guideline factors that are involved in reaching that outcome. Prior to rolling it out, we could have it evaluated. We could show that its sentencing advice is consistent with the sentencing of experienced judges. To do this, we would have to have three partly separable AI components. We would have to have natural language processing, which processes the evidence with identification of the sentencing relevant information. We would have AI that maps this evidence to sentencing relevant factors. And finally, we would have to derive the sentencing advice from the mapping and the weighing of that. It's important to note that even if a magistrate or judge doesn't adopt the advice, it's likely to influence the final sentencing because of the psychological anchoring effect that if you give someone a number, the number they'll come to is more likely to be close to the anchor they were given initially than if they were just reasoning without an anchor. So the case we want to consider is a person, JH, who is convicted of exposure, the Sexual Offences Act. And the judge uses the AI sentencing advice developed by the Sentencing Council. It says that the appropriate sentences in JH's case is 6 months in custody. And the judge also reviews the relevant factors that the system says. JH thinks that the sentence is too harsh. What would it be reasonable for JH to expect in terms of explanation? And of course, there are many factors involved. This is just the offense category part. You have to have factors indicating raised harm, factors indicating raised culpability, and so on. And this is just part of the sentencing guidelines. So there are lots of things that has to be taken into account. Now, what would it be reasonable for JH to expect in terms of explanation? Well, the decision-making algorithms of jail time are in some ways explainable. The output is not just a piece of black box sentencing advice, but the judge will have a list of factors from the sentencing guidelines that have been identified as relevant. Of course, the list can and should be checked by the judge as part of the sentencing process to weed out any sort of obvious system errors, which there might be, since no AI system is perfect, even if it might be as good as an experienced judge, maybe even better. We have no reason to believe that it will be perfect. This list could then be used as basis for sentencing remarks and for an explanation of the sentence. But this does not exhaust JH's reasonable expectations in relation to contestability of the advice. Now, Thomas and I have worked for some time on medical AI advice, and part of what we argue is that there are certain areas that patients who get a diagnosis can reasonably contest. It's the AI system's use of data, the AI system potential biases, the system performance, and the division of labor between the system and healthcare professionals. Now, the last part of this is less relevant here because the division of labor is likely to be defined officially by the Sentencing Council before the implementation of the AI system. But what else can we transfer to the legal context, and what modifications are necessary in such a transfer? Now, if we look at use of data, and I should probably explain the color coding here, the green are the kind of things that we could explain straight off, or that we can control for in the development process. Whereas red are the issues where we would argue that JH still has a valid claim to contest them in his specific case. So we can explain what data sources the system uses, but there's still problems with the validity of these sources, including the validity of natural language processing. Now, we know that AI natural language processing has various biases. It processes male voices better than female voices. It processes voices that speak standard English better than voices that doesn't, and so on. So JH could plausibly claim, well, some of the evidence in this case hasn't been processed correctly. Then, of course, it's also well known that AI systems can have biases which come in for various reasons during development. And of course, we can test for certain kinds of biases during development. Those we are aware of could happen. We could look at the training set that the AI is developed. But that doesn't exhaust the possibility of bias. There could be specific bias in the instant case. So JH could contest on the basis that the system is biased against people like him. That might be racial bias, it might be other kinds of biases. Now, explaining how the system works doesn't affect this particular claim, because however much we check for bias during development, there could still be biases that we have not discovered. So we would have to have a case-specific way of dealing with this particular issue. And then, of course, there's finally the issue of system performance, which we would have to test during development. There's also here an important issue about what the performance metric should be. Sort of how do we decide that the system is as good as an experienced judge? How do we identify experienced judges, and so on? And also, how does the system communicate uncertainty? When it says that a particular sentencing factor is fulfilled, does it communicate that it is uncertain about these areas? So our conclusion is that whereas in such a system for giving sentencing advice, there are lots of areas of potential explainability and contestability that we can control during development. There are also areas where, in the particular case, there are still issues that can potentially be contested. Thank you very much for listening.
Thank you. That was an excellent presentation. And again, we're looking at practical issues in relation to responsibility and inbuilt bias. I mean, one of the questions and issues that's been raised that we could perhaps look at later is how would somebody actually prove bias given the expense of the legal process, and how you evidentially would do so, but we could come back to that. So next we were looking at Joe. So please, could Joe take the virtual floor?
Super. So hopefully everybody can see those slides. So today my colleague and Jack and I are going to talk about what we call the presumption of disclosure in relation to models used in government decision making. So in outline, what we're going to say is this. We're going to provide a little bit of context on the growth of the use of models, potential risks and benefits, and some of the tensions around transparency, which will be familiar, I suspect, to most people listening to this presentation. The key point we want to make today, though, is that we want to focus on the response that public law principles can provide to this issue. And our argument is that there is already a clear line of authorities in the common law which establish a strong presumption in favour of the disclosure of models. And we're going to present that as a three-stage analysis or a three-stage test. Next slide, please, Jack. So just for some context, models and government decision-making. So in essence, a model is a simplified representation of some aspect of the world. The possible subjects or targets of a model are virtually endless. It picks out certain important features, expresses relationships between them, and other potential reference points. Within government decision-making, the use of models has grown exponentially in recent decades. So particularly prominent in areas like public health, environmental decision-making, or decisions where resource allocation is in play. Obviously linked here as well to automation and AI, hence the link to this panel. Next slide, please, Jack. So very briefly, in terms of the potential benefits of using models, obviously models can provide insights into the world and to decision-making that are beyond the reach of ordinary human cognition. A model can also promote consistency, so where officials are taking decisions, if there's a model in play, then that can help focus decision-making and ensure that the human elements of discretion are reduced and therefore promote consistency. There's also potential for models to reduce costs. So models can help reduce costs in terms of research and evaluation costs within government. Generally, models might also be attractive to public officials because they're a way to make complex decisions that don't rely solely or so much solely on their own professional judgment. Next slide. So obviously models also come with risks, a variety of risks, some of which we've already discussed today. So there could be problems with the construction of the model. There could be errors or flaws in the data in which the model is based. And there's also potential problems to how public officials themselves interact and use the model. What do they take away from the model? How do they factor that into ultimately their decision making? So in terms of transparency, the tensions around model decision making are pretty obvious, but just to run through what some of the key tensions are. So people who are subject to model-based decision making with good reason may want to be able to closely scrutinize the model, challenge the model, look closely at the basis of the decision that's affecting their rights and interests. And from a public law perspective, or from a judicial review perspective, being able to challenge decisions based on models, you often want to look at the basis for the decision very closely. And even to apply the most basic public law principles, such as rationality, sometimes you have to look in detail at the models that's being used. So there's an essential preliminary issue before applying general principles of public law and other principles of law, which is when a model ought to be disclosed and if a model ought to be disclosed. Next slide. At the same time, government officials have often been reluctant to fully disclose the models that they use. So there's a variety of reasons that can be put forward, some legitimate reasons, I would add, for not disclosing models used in public decision-making. So there is a widely perceived risks in the use of models that if models are published, then people might be able to abuse or circumvent government decision, the basis for government decision-making. Another perceived risk is that disclosure might damage commercial interests. That's a reason I'm more skeptical of myself, but it's a reason that we see an increasing amount. So obviously there's a range of potential responses to the issue of transparency around the use of models in government decision-making. So, for instance, we could think of a register of some kind or other mechanisms. And those mechanisms, in my view, are really important and definitely where most of the thought in this area should be directed. However, the way we view judicial review is that it's a really important backstop, and the principles of judicial review can be really helpful in providing a safety net in this context. So we're concerned, and we're going to focus on public law's response to that tension. So now I'm going to pass over to Jack to take you through the authorities that we think support the proposition that there is a presumption of model disclosure in public law.
Thanks very much, Joe. If everyone just bears with me for a moment, I'll just need to get my notes up. Sorry about this, just had a little technical issue. Okay. There we go. Thanks very much for bearing with me. So as Joe mentioned, we're looking at public law's response to issues of disclosure and transparency with model decision making. And I'm going to go through some of the main cases that have developed what we think is a presumption of disclosure. So the first case is a case called ISI. You can see sort of the basics of the case there on the screen now. The core decision that was at issue in ISI was a decision by the National Institute for Health and Clinical Excellence about whether to approve the use of the claimant's drugs in the NHS. NICE had used an economic model contained in an Excel spreadsheet to assess the cost effectiveness of ISI's drugs in then issuing a guidance about whether they'd be used in the NHS. And during its consultation, it provided consultees with a read-only version of the model, but not with the fully executable version. ISI challenged NICE's decision, and the Court of Appeal found that it was unlawful for a denial of procedural fairness. Fairness required the disclosure of a fully executable model during the consultation process for three key reasons. The first was that NICE's decisions had a significant impact on people. They determined the availability of treatments in the NHS, which could have a substantial effect on people's quality of life. And this required a very high degree of transparency in the process. The second was that the model was central to NICE's decision-making. Its reliability was a key question in the consultation and something on which consultees, including ISI, might probably have something to say. And the third sort of limb of the court's reasoning was the claimant required a fully executable version of the model to properly test its reliability. So we have a chain in the court's reasoning from the decision, model in the decision, to then what information or what version of the model is required to properly test its reliability. So NICE had actually disclosed a great deal of information to the claimants, but that still wasn't enough to discharge its duty of procedural fairness. NICE had attempted to resist disclosure on two grounds based on confidentiality and administrative burden, but the court rejected both of those. We move to the next case, which is also in the context of NICE decision-making involving a claimant called Serbia Laboratories. This had very similar facts to ISI, but it more squarely raised the issue of confidentiality. In ISI, the court had found that NICE didn't actually owe any duty of confidentiality in relation to the model there at issue. It reached the contrary conclusion in Serbia. It found that NICE was under an express duty of confidence not to disclose the relevant model. But it concluded anyway that this didn't justify NICE's non-disclosure. And so it's a really interesting example of the courts attempting to work out and resolve a tension between public law principles of procedural fairness that require disclosure of the basis of the decision and competing obligations of confidentiality. And essentially the reason why NICE's competing duty of confidentiality didn't triumph in this case was because the court held that even where NICE had such an obligation, it was under a positive duty to take all reasonable steps to obtain permission to disclose the model once it was an issue. So it had to approach the researcher whom it had got to develop the model and seek their consent to disclose it to Serbia Laboratories. And because it didn't go to those reasonable steps to obtain disclosure, its decision was unlawful. So I'll just move briefly now to discuss a couple of the other contexts in which the courts have applied the principles in ISI outside the NICE.
I don't think your slides are moving. It might just be me, but we're still on.
Oh, are they not?
ISI.
Oh, we're still on ISI. Dang. So that's not moving there?
No, we can see the presenter display.
Okay. Sorry, just give me a moment. Can you see that now? On Serbia Laboratories?
Yeah.
Yeah, great. Sorry about that. So that's ISI and Serbia. And I just want to briefly move now to look at a couple of other contexts in which the same principles have been applied, but outside the context of NICE decision-making. So the first of those is the British Dental Association and General Dental Council. So the decision at issue here was the General Dental Council's decision to increase the annual practicing fee for dentists. The rationale for that decision was a predicted increase in fitness to practice complaints and hearings, which itself was based on modelling, but the council had failed to disclose its modelling in its consultation, and the court held that this rendered the decision unlawful. The next decision is in the context of legal aid decision-making, a case called Ames. So the claimant sought judicial review of the LAA's offer in respect of counsel fees for his criminal defence. The LAA had refused to disclose to the claimant or his lawyers the calculator it used to determine the level of fees offered, and the court held that this refusal of disclosure was unlawful. The calculator was only part of the legal aid agency's decision-making process, but it was a very important part, and without its disclosure, neither the claimant nor the court could know whether the agency had made basic errors in assessing the claimant's fees or whether any such errors were material to the decision. The agency resisted disclosure on the ground that the calculator contained some confidential information, including ostensibly the names of some individuals. But the court rejected this, finding that any genuinely confidential information could have been redacted before the calculator was disclosed. And the final case I'm going to look at is in a disclosure context specifically. So in the context of litigation on foot, and this is a competition regulation decision, HCA, International Limited and Competition and Markets Authority. HCA sought review of the Competition and Markets Authority to require it to sell off 2 hospitals. And that decision was based on modelling of the market for private healthcare in central London. In the course of the proceedings, HCA applied for disclosure of the model and the data, and the Competition Appeal Tribunal, chaired by Justice Sales, as he then was, applied the same principles that apply in an ordinary judicial review and granted the reasoning based on the reasoning in ISI. And it noted, interestingly, that the public law principles of procedural fairness and fairness in the course of the conduct of litigation have some significant family resemblance. So the principles in the procedural fairness context could be applied in determining whether an application for disclosure in the context of litigation should be granted. So just to finish, just to draw together the threads that we think emerge from these authorities, we think that these principles support a clear presumption that the government ought to disclose the models it uses to make decisions. And we think that they give rise to what can be seen as a three-stage analysis. So the first question in the analysis concerns threshold. When does this presumption apply? And we think the authorities show that it applies where a model plays an important role in the exercise of an administrative power that might affect people's rights and interests. This raises further questions of timing and function. So in relation to timing, it's a question about when the presumption is triggered, and we think the authorities show that it applies at least from the point when the government proposes to exercise a power in a particular case, but it might in principle apply at an earlier stage where the government creates or acquires a model in the first place. The second stage of the analysis concerns content. So where the presumption applies, what does it require? This depends on the circumstances. Broadly, which is obviously a very lawyerly answer, but broadly speaking, the government must disclose enough information to enable those potentially affected by a model to regulate their conduct accordingly and to meaningfully challenge the lawfulness of a decision made with the model, and to enable the courts to meaningfully assess such claims. The presumption could arguably be more demanding, we think, where more important rights and interests are at stake. And the third stage of the analysis is what we've called rebuttal. So where the presumption applies, on what grounds and in what circumstances can the government rebut the presumption and resist disclosure? And we think to this stage, the cases show that the courts are taking quite a robust approach to attempts to rebut the presumption of disclosure. So it's going to be difficult, we think, for the government to resist disclosure on grounds of either confidentiality or administrative burden. So in relation to confidentiality, we see the court in a case like Serbia Laboratories saying that the government has to overcome several hurdles in order to resist disclosure. And in relation to administrative burden, the courts have generally conducted a broader balancing of the competing interests at stake. But generally, if the presumption requires the government to disclose a model, the courts have indicated that they'll be very slow to allow administrative considerations to stand in the way of that disclosure. That's all I'm planning to discuss this morning, but I will note that we have a longer paper discussing these and other cases RN if you're interested. We look forward to the questions. Thank you.
Thank you there to Joe and Jack. That was a fascinating paper. Really interesting to see how existing procedural provisions actually interact with this decision making. So many questions that raises. In terms of all our papers and the wider panel, I'm now going to turn to Professor Ian Walden, who is our discussant in this particular panel, to draw together some of the key themes. So please, I'll hand over to you, Ian.
Thank you very much. I've never really been sure what the role of discussant is, so I'll probably go with the devil's advocate approach to being a discussant. Thank you very much for the three papers. I just wanted to sort of raise a few comments on each of them, and starting with Dr. Ulgen. There are a number of problems clearly with decision making. There's automated decision making. There's a problem of allocation. You know, what sort of rule should we have for allocating liability? Should it be strict liability or negligence liability? We have a problem of attribution, as mentioned. We also have problems of substantive law. Causation. Could we address causation by having some sort of evidential presumption, or do we need to enhance the standard of care? And the final issue is one of remedial law. How are we going to remedy these situations? And I think one of the questions that were raised in the chat were about remedy. But I suppose my devil's advocate bit is the human-centric approach. Are you seeing that being applicable across all decision making? Because you made this distinction towards the end between deterministic and non-deterministic influences, and you use this phrase pure reasoning, which struck me as is one of those legal fictions. Clearly, I very much believe that one of the issues about human decision making is the exercise of discretion, which is something that machines can't necessarily do at the moment. But you referred to whimsical involvement in pure reasoning, and you didn't mention bias and prejudice. So I wasn't quite clear whether, I mean, you seem to be damning deterministic AI decision making in favor of pure reasoning and non-deterministic influences, which are really a legal fiction, because one of the whole purposes of AI could be to actually, make transparent the bias and prejudice as it has existed in existing decision making, particularly in the judicial area, whether it be on the basis that the judge is hungry, or the judge is old, or the judge is male, white, upper class, whatever the bias. We know how much bias, prejudice, and inbuilt. I wouldn't say any of those things were examples of pure reasoning. So the human-centric approach, my question to you really is the human-centric approach just applied to a particular type of decision-making, or are you seeing it applied across all decision-making? With regard to Soren, explainability, very interesting. The role of the Sentencing Council, I think, is the sentencing guidelines are really key. I think the interesting thing about judicial decision-making is again, I suppose, following on from the previous presentation about on what basis these decisions are made. If you look at the GDPR, Article 32(2), it lists 11 criteria for regulators to give consideration of when making decisions. We classically talk about when a tribunal makes the decision, it comes to a decision, it then looks at the mitigating factors, then looks at the aggravating factors, all of which are well known and well tried. But then we come to this issue of proportionality, one of those wonderful legal fictions that completely flummox us every time. What is proportionate in the circumstances? I mean, if nothing sums up the idea of law as a finger in the air, that notion of proportionality could be one. And I suppose you pointed out some of the things we can solve and some of the things we can't solve, and you noted one, the problem of solving bias in a specific instance case, and of course, I suppose the devil advocate part I would mention here is that classic phrase is "don't let the perfect be the enemy of the good," and I think it's both applicable to this question of explainability as well as the human-centric approach. AI is not the enemy. AI provides great capabilities. We need to be careful about how those capabilities are deployed, but let's not let the perfect be the enemy of the good. If we can actually, there will be specific biases in instant cases, but if the system still does it better than a human does it, then is that not perhaps in the round a better result? And finally, Joe and Jack, thank you very much for that analysis. The question I suppose I had with regard to you is what you described from my perspective was the Freedom of Information Act 2000. I mean, it has a presumption of disclosure. It has exemptions which are narrowly determined, need to be narrowly interpreted. We have an information commissioner as a surrogate and an appeals body. We have a specialist tribunal. Judicial review doesn't strike me as the easier or the best way to deal with these things if we've got an FOI system that works perfectly. So apologies to all, but I think my job was to be the devil's advocate. Thank you very much.
We have a bit of time left. Thank you so much there, Ian, with your devil's advocate approach. We have a bit of time left. I'm wondering whether quite quickly the participants would like to respond, our paper givers like to respond to any of the issues raised there. Any volunteers there? And yeah, with the questions on the Q&A as well. There's definitely a question in relation to freedom of information, the issue that Ian picked up there. So perhaps Joe and Jack could take that further.
Yeah, sure. So I can start, and then Jack might have some additional comments. I guess the central point here is that you're entirely correct that there are different regimes, if you like, for thinking about this problem. so Freedom of Information Act, GDPR, etc., different kind of frameworks of thinking about it. And I think it's important we recognise there are parallel regimes within the law, and the regimes you describe, freedom of information, for instance, are in some ways good, but also imperfect. And at some point, I suspect the cases, judicial review cases that rest on common law principles are going to arrive. The cases that we discussed are some examples, but we're going to see more and more of those as the years go by. So this is an area that's almost a kind of parallel legal regime, which I suspect will develop quite quickly in the next 10 to 15 years. So it's certainly not a case that we're saying this is the way forward. This is the best regime. We're just sort of elaborating that it exists or is coming into existence as an area set of principles. And it is one that we need to be aware of when we're having the discussion of the legal principles that apply in this context. So yeah, that's the main point. I totally agree. Just one final point. Totally agree that there are better ways of dealing with these problems generally than judicial review. Judicial review, because of its position, because of problems of access and a whole variety of other features, is never going to be a perfect system for dealing with problems within public administration. But as I said in the presentation, it's also an important backstop for when those other systems, those other ways that we've put in place to deal with those problems fail. So that would be my response to that point. Jack, I'm not sure if you've got anything else to add on that.
No, I mean, just to echo your response, and I think, it's not saying that I don't think that this presumption of disclosure should apply to the exclusion of other frameworks. I think we think there's a need to marshal all the tools available to ensure that these systems are held accountable. I suppose the couple of things I'd say is that I think so far researchers have found FOI to be quite a frustrating framework to try and access these systems. And obviously, the presumption of disclosure we've fleshed out, that's not in a fully fledged form yet either, but, limitations on the cost limit, the timing that it takes to get information from government departments, the, various exemptions that can be relied on. For instance, fears that if information is disclosed, that it will be used to circumvent government decision-making. That might mean that the rights to disclosure that FOI give you in some places aren't as strong as the ones that you might have under the common law for decisions being made that affects you. But I think the main thing is to keep all these irons in the fire from our perspective, and to think more about, with respect to the common law specifically, what kind of systemic impact can better and more specific development of these principles have? Because I think from my perspective, something like basic procedural fairness is now so well established as a common law principle. You don't need a threat of judicial review in every case for the government to disclose, basic reasons for decision or to give people a right to a hearing. That's now so well established that bureaucrats and government lawyers comply with it as a matter of course, in most cases. And so we'd hope, well, if a similarly powerful presumption of disclosure applies specifically in model decision making, that might then be established to then be complied with as a matter of sort of institutional culture rather than threat of legal challenge. That's all I'd say.
Great, thank you so much. I know that Özlem has a point of response to make, and from the Q&A, issues were raised about how long it can take to get cultural change in relation to responsibility and related issues. So, please.
Thank you, Catherine. Thanks very much for the question and also for Ian's provocative response. Just to pick up on Ian's point, it is, of course, very easy to overstate the benefits and the so-called goodness of AI. And what the human-centric approach and the life cycle approach is doing is looking at the full spectrum of development, deployment, and post-deployment. And within that, it's trying to situate actors, human actors, who can be attributed with responsibility. It's not in relation to considering a specific decision system. It's actually across all sectors. And these have proved problematic in, for example, determining student grades, personalized online marketing, approval of financial credit applications, the pre-trial bail risk, and at the extreme end, targeting of humans in terms of target selection in warfare. The point about the bias and prejudice, well, that's not necessarily an issue about whether or not to take a human-centric approach. It goes to the heart of, if you like, the pre-deployment stage, whereby you're designing and developing these systems. And the example I gave early on about the sets that are being used, data sets, and whether these are translatable, whether they are truly reflective, and whether they take account of existing values. So I think there's that approach to take. And on the pure reasoning aspect, what I was trying to explain is that that faculty of engaging in inconclusive and whimsical thinking, as I referred to it, where you're able to think critically and think in abstraction, that's very good with human beings. That's not something that the decision support system can do. And it's actually that sort of pure reasoning that's going to lead us to critical thinking of whether to deploy such systems, in what scenarios, what context, and have we assessed the risks and potential harms, and therefore the attribution of any liability that may result. And that's what that's trying to get at. And I think one thing that may be possible is to ring fence those contexts and scenarios which do require that so-called pure reasoning. And just one final point. The decision support systems that are deployed, I think we have to be careful of understanding the reason for the deployment. Is it pure efficiency? I mean, we hear a lot about human errors. Part of the reason why we're able to identify those is precisely because there's human involvement. And the cases that were alluded to, very interesting cases on the disclosure. I'm wondering how far it is possible for individuals to engage in such a process if you had a DSS system, because they seem to be pretty predominantly cases relating to corporate entities. How difficult is it going to be for the individual to have the knowledge to understand exactly which particular DSS system is being used, what its thinking is, and then to be able to identify the error and then to be able to bring the case before court. The final point in the chat box that was raised, a long question, thank you very much. These are not privacy concepts as such. The privacy and data protection rights are part of that second component of protection of rights generally. So privacy is one aspect of that, but the human-centric approach is not just focusing on privacy. It's focusing on the actors, it's focusing on the purpose of deployment of the system, it's trying to understand where there may be attribution of responsibility and on what basis, and how we can mitigate that through protection of rights and making it more user-centric and protecting their interests. And I think that's all now. Thank you very much. Thanks.
Great, that's fantastic response there. Many thanks. And I know that Soren wants to give a response to what was mentioned in the discussion section, but also I can see from the chat there's a lot of questions about the practicalities of how to deal with bias in these systems. So thank you.
Well, first of all, now the argument that we want to make is not that we should not use AI systems in the judicial area at all. The argument we're making is just that when we do that, we have to think carefully about how we implement them and whether we need to make further changes to the processes. So let's just take sort of the standard example of potential racial bias, which we have reason to believe exists in judicial decision-making as in most other forms of decision-making. Now, in the development of an AI system, we can do various things to check for sort of obvious racial bias. And we might even be able to do some things to check for some of the proxy. The standard example is that if we allow, say, a system can't take account of race, but still allows it to use people's postcodes, race might still creep in, because postcodes in the UK, because it's very granular, is a quite good proxy for race. So the AI system may pick up on that, even though we don't allow it. So one possible issue, and this is sort of a potential overlap between our paper and Joe's and Jack's paper, is that in many cases it's of no help to anyone to get access to the support vector machine model, because going through it and understanding what it does is hugely expensive, and you might not understand it anyway at the end. Now, what could be of use to a defendant or a claimant is to say, I think I've been discriminated against for these particular reasons. Now, could you please run the model again with slightly different parameters? Now, that is not hugely expensive and is definitely possible, and is a way to, if sort of you suspect that you are the subject of specific bias, is a way to contest that specific bias. And it's along those lines that we think we should think about contest the sort of including possibilities of contesting AI advice in the judicial sector.
Right. Thank you very much for the response. And the general's final question come up for the panel. To what extent is the identification of bias by the human decision makers a priority for the developers? Would you say it was something that was a high priority, primary one? I've got a secondary one there as well. Anyone like to answer that in relation to their work?
Well, I suppose one answer would be, I mean, as the GDPR talks about, it depends on the nature of the decision. Does it have, legal significance, or produces legal effects, or is significant effects? In those two cases, then clearly bias is critical in order to ensure that the system operates in a just mechanism, but also that we are able to give individuals the right to appeal against those decisions. And that's why I think the GDPR was drafted as it is. I mean, my concern with Article 22 of the GDPR is more the extent to which the exceptions may be used, particularly by the public sector, to sort of avoid this process, because the use of automated decisions when authorized by member state law is an exception subject to these appropriate safeguards. And we know how, we recently had that case in the UK looking at number plate recognition where the appropriate safeguards hadn't been put in. So that was good. But again, we need more guidance for the public sector about, the quality of the law that needs to be laid down in order to implement an automated decision making which doesn't allow some sort of appeal through the GDPR.
Great, thank you. A general statement to make, but from my work with developers, what I find so difficult is finding a way to really, truly, and tangibly embed a focus on the end result and the end user throughout the whole developmental process. And it's actually kind of cracking that seems to be where many of the problems lie. I think that's us. I think, yeah, we're just there on time in terms of this particular panel, and it's been a fantastic discussion. Thank you so much for all the participants and for all the questions and for the amazing depth and breadth of debate there. Obviously, we really hope to see you back for the next panels, but then there is the 4:30 event where over virtual drinks we can meet our speakers and perhaps engage in a bit more of the discussions on the issues that we've been raising here. So thank you very much and hope to see you all soon. Excellent.
So my name is Christopher Millard. I'm Professor of Privacy and Information Law at Queen Mary University of London, where, among other things, I lead the Cloud Legal Project. But just in case you think I'm only interested in technology law, in a former life, before I became what was called a computer lawyer in 1982, I was a criminologist. Now, to be honest, I only dabbled in criminology for a couple of years. I did a master's in criminology at the University of Toronto. I was a very junior researcher on a project for the federal government of Canada, but it happened to be on the prediction of dangerousness. So it's kind of relevant for today, and I'm absolutely delighted to have the opportunity to chair this panel and to hear the latest state of the art on criminal justice and predictive analytics. I should say, by the way, back in the day, I was locked up in a secure room in the middle of a psychiatric institution reviewing some pretty disturbing files and coding them all so that we could do an analysis for the purposes of predicting recidivism or reoffending. And once we'd controlled for all the variables, and this was a pretty low-tech project compared to how you would do it today, I'm afraid we concluded that the only relevant variable was that people tend to get less dangerous as they get older. Now, I'm imagining there's a lot more to it than that. We've had Minority Report since then. We've got lots of experiments going on, some of which we're going to hear about in a few minutes. So I think this is a very exciting panel, very exciting time to be visiting this topic. And we have a lot of speakers and a lot of content. And the first paper is Data Analytics in Policing and Participatory Oversight, the West Midlands model and its role in the regulatory space. And I understand Jamie, Tom and Marion, you are all going to say something about this, but please do that. And we will then see if there's time for questions after that, or possibly we'll just press on until the end of the panel and have a broader discussion. Because as I said, I'm keen to get Bethany's comments on everything. So I'd ask you please to very briefly introduce yourselves as you start speaking. Thank you very much. Over to you, Jamie.
Thanks, Christopher. I'm starting off on behalf.
Oh, I do apologise.
So it's okay.
Welcome to Marion then.
Okay. I'm Marion Oswald from the Northumbria University, and I chair the West Midlands Data Analytics Ethics Committee. What we'd like to do in our panel is three things: introduce you to the West Midlands Police Data Ethics Committee and its role within policing and data analytics, give you some initial conclusions from some research into the role of self-regulation within the regulatory space, and also then set out, and this is what Tom will do at the end, a case for a national ethics institute in this whole area of policing and data analytics. I'd like to start off on the next slide by asking a question. Is ethics all we need in this space, in this area of policing and data analytics? And I'd answer that question by a quote from Murray Hildebrandt, who says, ethics is both more and less than law. It's more because many ethical concerns are not addressed by the law, and it's less because the outcome of ethical considerations are not necessarily transformed into legal norms and thus not enforceable by way of law. And she goes on to say that ethics provides for reflection as to the right or moral thing to do, and law provides for closure. And we've been very aware of that distinction in the operations of the committee, and also, if we have the next slide, of the need to avoid ethics washing, as Ben Wagner set out. And how do we avoid high-level aspirational principles that give little or no concrete guidance to police officers operating on the ground? And the way that we think is important to do this, of avoiding those high-level aspirations and little or no concrete guidance, is to focus very much on the public body, in this case, the police services legal function. What are they there to do, and how, if at all, can data analytics contribute to that legal function? To have a process for accountability, clear human accountability, and to keep the strong link relevant legal frameworks, and we've heard about many of those during this conference, and recently public law principles, which I think are extremely important in this space. So to introduce you to the West Midlands PCC and West Midlands Police Data Ethics Committee, rather a long title, but here we all are on the photograph. For some reason I seem to be hiding in the shadows. Jamie's very much front and centre there. So this is our committee. It was established at the beginning of 2019 and has a variety of members, some of which represent the police service, but the majority of which represent a number of different areas of expertise and interests. Next slide, please. The committee was set up alongside the West Midlands Police in-house data analytics lab, which is an area of the police force specifically designed to investigate data analytics and to develop ways of analysing data specific to the needs of the force. The committee was recruited against specific skill sets. It has a very clear commitment to transparent terms of reference, papers and minutes, and sits alongside the legal advice and the legal data protection compliance that underlies the whole process. One thing that I think is very important is that our review of projects is not just a one-off review at a particular point in time. That our terms of reference are very clear that we will follow projects through the process from initial idea to design to testing and through to potential operational stages. If the PCC, the Police and Crime Commissioner, or the Chief Constable decides not to follow the committee's advice, they will ordinarily provide open reasons for that. And in return, we as a committee are asked to provide that sort of pragmatic advice to the force that will enable them to implement our recommendations within the activities that they're doing. We judge the projects that come to the committee against a set of principles, and these are set out on the slide. I won't go through all of them, but I would just highlight the public good principle, non-discrimination, and the key areas of necessity and proportionality. And also that we spend quite a lot of time thinking about the rigorousness of the data science methods that are being used. And to give you a couple of examples from our meeting minutes, this is an extract from the minutes of the first meeting back in April in 2019, where you can see that we have, as well as focusing on the data science, the data inputs and around the tool, the committee tends to focus very strongly on how a model is going to be used operationally and what the benefit will be, what the potential interventions might occur. And then this links very, very strongly back to those principles of necessity and proportionality in order that those can be judged. And then to give you an extract from a paper that's only recently been presented to the committee, this relates to a network analysis tool around modern slavery crimes. This paper acknowledges that as the result of the committee's input, a number of very specific changes were made to the design of the tool, highlighting the handling of the output, identifying that the output was intelligence, not fact, which is very important in a policing context, and also acknowledging the need for very clear information to be given to officers about the reliability and the confidence around the output. So I think this demonstrates that the committee, as well as giving more general advice, has made some very specific strides in terms of the design of the tool and the interface with the officers. So that's a very sort of whistle-stop tour of our committee. I'm going to hand over to Jamie now for some thoughts on the on the way that self-regulation fits within the regulatory space that we see generally in policing.
Hello there, folks. Nice to meet you all in this sort of virtual setting. I am Jamie Grace. I'm the Vice Chair of the committee that Marion's just been explaining so much about. And Marion and I have done quite a bit of research together. As some of you will know maybe, that we're kind of long-term academic writers together, and fairly long-term. We've been working together since about 2016. And I mention this because in 2016, we published a paper together that was based around FOI requests to forces in England and Wales to see how they were using machine learning tech, AI and advanced analytics. And we were really pleased with the paper that came out of that. And then in the interim, we've got involved with the National Police Chiefs Council, who've adopted the kind of output of another piece of research we published in 2018. And that's the Algo care framework, which is a sort of blend of different bits of legal prompting and some data science advice and some kind of policing language, all sort of meshed together really into a sort of checklist which acts as guidance to forces that want to innovate in this sort of particular space and in this sort of way. And we thought we would, in 2020, and with one thing and another around the coronavirus pandemic, it will really be more 2021. We've sent out another wave of FOI requests, and you can see some of the details on this slide here while I'm talking. And I know Marion, and you'll see on the next slide, Marion's already been doing some interviews with officers and data scientists in different policing organisations in England and Wales. And I think Marion has plans to do more of those to bring the research project along a lot more. But at the moment, we had FOI responses in the sort of positive sense from 17 forces who made substantive disclosures to us that they were using analytical tools, AI, ML and data analytics in different ways. I don't have time today to go into the details of those responses, but the key finding is it's a real variation amongst those 17. And actually there's a real variation in the degree to which forces are self-evaluating. So I would probably say this, being a member of an ethics committee affiliated with them, but West Midlands would sit top of the tree. But after that, in terms of self-evaluation, clarity and transparency, and pushing themselves as forces in terms of governance, there are some other leaders in the space that our FOI requests have started to sort of show. And it's not just the ones that apply the Algo care framework, it's the ones that have set up their own ethics committees and oversight partnerships with other authorities of different types, like Essex, for example. It's forces like Cambridgeshire that are bringing in academic evaluation from outside experts to kind of try and create a rigorous evidence base for their investment in machine learning tools. But Marion's interviews have started to throw up a few key points around all this. It is true that this is the main message really on this slide, I suppose. There's no single regulatory voice. The interview participants Marion has worked with have said that there is no real single source of advice for police forces on issues around data justice, if we call it that. The West Midlands approach is a sort of leader in that area, we would argue, but it doesn't have the right scope. It doesn't have a national remit. Its time and funding is not protected. And that's probably where I should hand over to Tom, our co-researcher and colleague, and he can explain a little bit about his proposals around a national institute in this area.
Thank you very much, Jamie. Thanks. My name's Tom McNeill. I'm a lawyer by background, but I'm the strategic advisor to the West Midlands Police and Crime Commissioner. And I'm going to briefly talk about our ideas for potentially turning the work we've done in the West Midlands into something a bit bigger and for the benefit of more people and more police forces and more stakeholders on the national scale. And we'd call this a national institute for ethics. Now, the first thing I should say is we're not saying that everything we do in the West Midlands is perfect. We're on a journey ourselves. There's a lot more work to be done around what public engagement would look like and how we bring in lived experience. But our ideas around a national institute would really try and build on where we think there are weaknesses, but also really kind of say, look, we think we've got something good here. I mean, Jamie, if you just pop back to the previous slide very briefly, The context behind this is clearly the Black Lives Matter movement has really brought back into sharp focus the very real concerns there are over institutional racism in society. It's actually always been there, this huge long history of these concerns. And a personal story I always like to mention about this, my granddad, when he came over from Jamaica to England, wanted to be a police officer and was told not to even bother applying. So these problems are obviously very long standing, but Black Lives Matter has really brought that into sharp focus, which makes ethics oversight of predictive policing, this kind of technology, so important. We also know there were some major issues with the criminal justice system in Western society, probably all over the world actually, but we are imprisoning too many people who quite frankly need care and support rather than punishment on account of their experiences of trauma, mental health problems, undiagnosed disabilities, profound poverty. And then connected, but not as direct, not about structural issues, then we've just got the data science issue, which Marion talked about, which is some of the data science that's starting to come out and be developed, whether it's predictive policing or otherwise, is it actually any good? Is it accurate? Is it fit for purpose? And so the ethics oversight needs to really bridge the gap between high quality data science and whether the tools and the technology is doing what it's meant to do, and then these huge social realities that surround the real need to be seen to be doing something, but something that's actually fit for purpose. If you go on to the next slide, please, Jamie. So two key concerns are, would a really poor artificial intelligence tool or predictive model wrongly predict somebody's criminality? That's ultimately one of the main questions we're always asking. Or will it create an inaccurate prediction of some kind? And then the other side of the coin is, it might be a fantastically accurate tool, whether it's AI in facial recognition or anything else, but is it going to be used in a way that exacerbates existing inequalities? Are we essentially going to use it for the efficient law enforcement and imprisoning of vulnerable young people? If so, it's a major ethical concern, and why we need to always be asking serious questions of anybody looking to use this technology. But the other big thing is there's just a very wide scale lack of understanding about technological products, full stop, about whether it works or not and how it works. And so we need this kind of expertise, but in a very diverse sense, scrutinizing this use of technology. Move on, Jamie, to the next slide. The other challenges, which I think really necessitate a more national approach, are the ethical standards being expected are constantly evolving. And we see that from new major legal cases, whether it's around facial recognition or otherwise. There's the fact that there's a lot of commercial players who are understandably kind of aggressively marketing their products because they believe in them. But we need to make sure that police forces or any public body or anybody using this kind of AI is really well informed about whether the product does what it says it can do, but also whether it has the institutional preparedness to be able to use that in the most responsible way. And I think the public demands this. Going back to that first point about the Black Lives Matter movement, which we can't let just pass by, can't just forget it now. We need to keep talking about it. The public expects this kind of level of scrutiny. And so what I think is there's a real opportunity to build on some of the knowledge and capabilities developed in the West Midlands for the benefit of the whole country, owned by all the different stakeholders, not run for on behalf of them, owned by everybody, to kind of really address some of these demands. Just move on. Next slide, please. So this little diagram here very simply symbolises, I think we need a new institute, and it really does need that diversity of perspective. And I mean both in a professional sense, different kinds of legal expertise, understanding of the real world and the real crime threats, because there are opportunities for technology to address real threats to public safety, but also diversity in every other aspect, cultural, religious, and actually the very people who might be affected by the use of this technology. And I'll almost finish up there. Just move on to the next couple of slides. One thing I really want to stress at this point, just before I kind of finish off, is it's so important that if we are to create a national body, that it really has the trust of all the different constituents. We know civil society have been very effective at raising some of the concerns just mentioned. We know the public have renewed expectations, but we also need the police forces and police agencies to trust that this isn't about just cutting down progress and technology, because they are having to see the very, very real world threats of very serious criminality, which quite frankly we're struggling to keep up with. So it can't be about being anti-progress and anti-technology, but it really needs all the assurances of all those different stakeholders. And the details of what we've got, and I'll be happy to talk about them on another day, are to really build on an awareness of the different requirements and expectations from all those different stakeholders. I'll end there because I know time flies away very quickly, but thank you very much.
Fantastic. A huge thank you to all three of you for a fascinating presentation and for sticking to time. Now, I think we're going to follow that with Jamie coming back on to talk about female victims of gendered violence, their human rights, and the innovative use of technology to predict, prevent, and pursue harm. So back to you, Jamie.
Thanks very much, Christopher. So, folks, I'll endeavour to be as brief as I can, very much stick to time, with the aim of facilitating as much time for questions, of course. But if anyone's got any questions that they want to put in the sort of chat function, then I can obviously pick that up with them in the chat function or in the live Q&A afterwards. So the reason why I wanted to give a presentation on this topic today is because I did start out several years ago as a sort of researcher looking at some of the issues that Marion, Tom and I have just brought up in the last presentation with a lot of skepticism, naturally very pro-privacy, but it's sort of teaching human rights and researching the role of the police in preventing domestic violence for my part-time PhD, which is like a project separate to this area of research. Actually, I'm sort of a researcher on Clare's Law, the Domestic Violence Disclosure Scheme as well. I've had cause to look at quite a lot of kind of evolving and changing, I think improving human rights standards that apply to the policing of domestic violence, partly created through a kind of evolution of case law principles as well. And then obviously that's then sort of flowed back into a little bit of the work that I've been doing in this particular space around tech and data justice in the policing sort of practice context. So the first thing to note is that by working through the West Mids Committee, I've gained a much better understanding of what it is police forces could do. And indeed, I think that the Data Lab at West Mids and other bodies around the UK are doing by using the data that they sit on and have sat on for a while, using things like machine learning approaches. And there is space, really, there is room for a more developed culture in using this to work in a way in UK policing that has much better respect for victim vulnerability, and stays away from the idea of using tech in a way that re-entrenches bias, re-entrenches and reinforces inequality, but actually does policing in a much more targeted way, better than before, better than now, in terms of things like risk assessment. And in doing so helps meet human rights compliance duties as well. The big problem, of course, is not only bias, which must be acknowledged and must be monitored and minimised in the way that policing tech around machine learning and so on augments police decision making or structures police decision making, you might say. But there is this fundamental problem of what Julia Black has called the fragmentation of knowledge. You're building data tech off the back of bodies of data that you know are not the full picture to any problem, and that's possibly worsened by the black box problem as well with some tech in this area. So just as a little overview of why this is a pressing human rights issue for those who are not familiar with the prevention of domestic violence as a problem as researchers, in the year ending March 2019, more than 1.3 million domestic abuse related incidents and crimes reported to police in England and Wales. There's then a fall off, if you like, in how the police treat those reported incidents. Nearly 750,000 out of 1.3 million are actually recorded as crimes. You then get a far smaller fraction than you might imagine. Only 32 arrests out of 100 domestic abuse related crimes come about as a result of those crimes being recorded. And then again, there's like another lower proportion of referrals for charging. And then there's a lower proportion again of actual prosecutions, leading to, from 1.3 million reported incidents, just under 80,000 prosecutions begun in the year ending March 2019. And this is all, remember, in a wider sort of socio-political context of massive underfunding, as many of you will know, for the criminal justice system, the court system, the police, the CPS itself, and so on. So there is a big austerity picture here. But having accepted that austerity picture and the problems that all of that involves, where does tech in policing, where does data technology take us? Well, the first thing maybe to note is that domestic violence is a matter of inequality. In the worst areas of domestic violence in society, therefore, it's a matter of inequality between men and women, and therefore it links to a protected characteristic under the Equality Act 2010. Police forces have a duty under the Public Sector Equality Duty to be properly informed by showing due regard for that inequality. And so that actually came up recently in the live facial recognition case of Bridges against South Wales Police from the Court of Appeal judgment, at least earlier this year in August of 2020. And the Court of Appeal found that there hadn't been enough homework done, basically, by South Wales Police. They weren't properly informed. That's the relevant standard that the Court of Appeal reinforced in LH in 2014. So police forces, I think there's an argument that they should invest in the kinds of risk assessment tools that they could build to predict victimisation or risk of victimisation of domestic violence, risk of offending around domestic violence. From a matter of equality law, they need to be properly informed. There are some problems around accuracy and the requirements of the Data Protection Act 2013 to make sure that our risk predictions are as accurate as possible. So that's a legal question as well as a data science question. And there are some policy choices to be made into how you decide to use certain data sets, parts of data sets, and indeed the type of accuracy you want, i.e. how many false positives you're going to get, how many false negatives you want to avoid, and of course what you do with the predictions. So there are some human rights prompts, there are some human rights law prompts that come from cases involving the Strasbourg Court, the European Court of Human Rights. And so the classic Osman in the UK, the Article 2 case, the Article 2 duty on the state and on police bodies, therefore, to prevent death and homicide actually kicks in when there is a real and immediate risk to life of a person that the authorities knew or ought to have known. And it's that thing of, with that language of whether a public body ought to have known at the time of the existence of a risk to life that's real and immediate. You wonder what really data science can play in a role in helping us see police forces over time kind of do better risk assessment. And I know that there are some police forces, Hampshire, I'm well aware of through Marion's work with David Powell, who's based in Hampshire Police. There are police forces that think in these terms in terms of how they will use data and data tech. But Talpis in Italy is an important judgment in this area of policing practice. And the European Court of Human Rights made a couple of key points in paragraph 1, 2, 3 of this judgment. It's a really interesting judgment for those who aren't aware of it, as so much of the output of the Strasbourg Court is, of course. But you will notice that this is an Article 3 case. It's an Article 3 and 14 case. And so there's a positive obligation on police forces to put victims' human rights to life. And it was an Article 2 case too, but this extract is from the Article 3 and 14 element of the judgment, I think. The state has a positive obligation, the court wrote, to take preventive operational measures to protect an individual whose life is at risk. And this is a matter of anti-discrimination. This was an Article 14 case too. And so what's interesting is that there are some police forces, I mentioned Hampshire before, but also Northumbria. Northumbria have integrated a risk assessment tool, a machine learning tool, a recency, frequency and gravity tool, it's called RFG, into their prioritization process for deciding which interventions to target at which domestic abuse perpetrators in their force area. And that's been independently evaluated by a couple of academics and has been written about very favourably. The West Mids Data Lab has started to do a lot of work to unpick the factors and rank and prioritise really the factors that go into, amongst other things, why victims don't support prosecutions in domestic violence or domestic abuse cases, why investigations don't lead to prosecutions in cases involving rape and serious sexual offending, or RASO. And these are papers that we've seen, and I've only learned about because of my these are projects, I mean, that I've only learned about really, and I think the public at large only knows so much about through the work of the ethics committee we were discussing before. And of course the Home Office and other agencies are investing in the, I think, overdue and I fear over budget law enforcement data service about increasing real-time access. The problem in Talpis in Italy was a failing of a data flow. It was the inability for real-time access to see, for officers involved in dealing with a particular incident in a certain household, in a Talpis household, that there was an outstanding and pending prosecution for attempted murder against the man who had previously tried to kill his partner, and that kind of lack of real-time access to data was a significant problem. But it must be said that this is a multi-agency question as well. So it's not just about access, it's not just about analysis, it's not just about prediction, but it is about perhaps data pooling too. So Matthew Bland is an author whose PhD thesis is absolutely fascinating in this area. He did his PhD at Oxford, I think, and it's now been turned into a book already. And certain chapters are just brilliant in this sort of space. And he's written about the fact that actually there's a majority of serious domestic crime arrestees don't have an arrest record in the 2 years preceding a serious domestic crime. And so you do wonder whether data pooling would help kind of overcome that fragmentation of knowledge there. So the thing that I wanted to kind of end the presentation on really is just a little nod to the UK case law as well, and the important judgment in DSD in the Supreme Court in 2018. This will sort of push us, I think, over time towards a more intelligence-led policing of domestic violence that should be driven by data analysis and indeed machine learning and AI approaches, if those will lead to fewer errors in investigation, as Lord Kerr wrote, that give rise to a breach of Article 3 that could be egregious and significant, which is now the kind of the investigative standard to be applied to police, the work of police forces under Article 3 in the UK now. In the High Court, the High Court case had actually picked up on a number of factors around what could be said to be the kind of the right standard to measure whether there had been a breach of Article 3 in relation to an investigation which either didn't result in a prosecution or resulted in one far too late. And so I think there's obviously a large package of reasons why domestic abuse prosecution for a very serious offence might go wrong, might have egregious and significant errors in there. But I think that anything that AI and machine learning can do to speed up and make more accurate investigative efforts in a kind of time of austerity where there are resource pressures on the police service, even in such a serious area as policing domestic abuse and preventing domestic abuse. I think that's something that actually might be a human rights duty to invest in this particular use of machine learning technology. And I think it's sort of maybe becoming an imperative actually because of case law like Talpis and DSD. So my sort of only conclusions really at this stage in this paper are human rights duties actually mean that although avoiding bias and avoiding entrenching inequality in communities is really vital, we can't stop probably the ongoing application of machine learning tech in the policing practice context, because there is so much good that it might do to prevent harms of a very serious kind. But there is a legal duty on police forces and the Home Office to have due regard to the potential for data analytics as a matter of equality law and human rights law too. It will be interesting to see whether the Information Commissioner's Office forthcoming sort of data analytics guidance toolkit for law enforcement agencies will help spur practice on. Will the CDEI Code of Practice, which has been forthcoming in this area for a while, will that help build momentum for forces? And really the big thing for me would be the College of Policing have a statutory power to produce guidance on operational policing matters. And I think we're starting to see maybe a culture develop where data tech in policing is becoming part of operational, not just strategic practice. And so doesn't the College of Policing need to kind of enter the fray really with advice and a statutory code in this area too? And thank you very much for listening, everyone.
Thank you very much indeed, Jamie. That was fascinating. I sense we're going to have a lively discussion later in this panel, because I go to a lot of conferences where almost all the presenters are almost entirely negative about any kind of use of algorithmic decision-making or predictions in the context of criminal justice. And we have, I think, a mix of views today, and that is always great for a discussion. But we're going to press on, and I'd like to welcome Marion back, and also Kiri, and they're going to present to us on zombie forensics in the Twilight Zone. Fantastic title, looks like it's come out of Black Mirror, but if not, it should be a future episode. So over to you two, thanks.
Yeah, thanks, Christopher, for the kind introduction. Kiri Kotsoglu is my name. I'm an academic at Northumbria University working on expert evidence and decision-making processes, and this includes those that are hijacked by algorithms. I did say that at the end. I couldn't hold back. So in the next 15 minutes, Marion and I would like to tell you a bit more about the use of polygraphs in the criminal justice system of England and Wales. So to begin with the next slide. The effort to separate in a reliable way truth from lies has been a dream of mankind since the very start. It has shaped mythology, philosophy, literature, fiction, and here are only a few examples of this ancient dream: to be able to detect reliably truth and falsehood. The ancient Greek god Momus was expelled from the gods and their mountain Olympus because he criticized Hephaestus, because the latter made humans as opaque, and he did not put our heart on the outside so that lies can be detected and thoughts can be read. And this shows something, I believe. Secondly, Mary Poppins with her famous oral thermometer, and if you have read the book Mary Poppins Returns, she uses the oral thermometer to detect that Michael Banks has been naughty, untidy, and careless, and parents can only dream of that. And thirdly, the Wonder Woman, the Marvel superhero, I think, with her weapon, the lasso of truth, and those that are trapped within this lasso of truth are forced to tell the truth. And finally, yet importantly, it's William Marston. Coincidentally, or not coincidentally, William Marston is the person who created the Wonder Woman, and is also the inventor of the first polygraph device. And this shows how obsessed he was with this idea of detecting the truth. Now, let me say one more thing about William Marston. He was the protege in Harvard from Hugo Münsterberg, who was a proponent of introspection, the idea that if we look inwards, we will detect something, but we can reduce complex normative psychological concepts to physiological reactions. And this is the paradigm of introspection, which is now obsolete, but still we are talking about the polygraph. In the next slide is why all this rather seemingly irrelevant introduction. Well, the polygraph, it has become increasingly an issue in the criminal justice system of England and Wales. It is in use, and the problem is, as Lord Lloyd of Berwick said in the House of Lords, that it is not very English, and it is not a scientific way of establishing the accuracy of the polygraph as an indicator of the truth. And with that, and we use that because we have used this catchphrase with Marion to give it as use it as a title for our paper on the polygraph. For me, it is important because it is not about some form of English exceptionalism. It shows that the polygraph cannot be embedded in the legal framework of the penal system in England and Wales. And in the next slide, you will see that the government is now increasingly deploying the polygraph to begin with in the Offender Management Act from 2007, which applies mostly to released sex offenders. And this brings us back to James' presentation, but also with the Domestic Abuse Bill from 2020 and the Counter-Terrorism and Sentencing Bill that line up to use the polygraph in the probation context. The question is also, as we will explain in a few minutes, if it's only used in the probation context or it's also used in other contexts, such as policing. And the answer is we don't know, and we will explain why. First, we don't know, and why it is quite a reason of concern. And I hand over now to Marion to talk about the project that we have started since a few months ago.
Thanks, Kiri. As a result of our concern about the polygraph, we set out to do three things in our research: to find out the purposes for which the polygraph is deployed by the police and probation services in England and Wales, what policies there were out there and procedures governing its use, and how is the use of the polygraph justified by its proponents. And we did that by looking at publicly available documentation and policies, and also through freedom of information requests that were submitted to the National Police Chiefs Council, the Ministry of Justice on behalf of probation, and all police forces in the UK. And the freedom of information results highlighted a number of concerns. We had 46 responses from police forces, 37 of which used a neither confirm nor deny response, justified on the basis of a number of different grounds. Only 5 forces denied the use of the polygraph without any further caveat. And this tended to reflect the differences in jurisdictions between Scotland and England in particular, with the Scottish government recently being very strident in their statement that they remain unconvinced by the polygraph itself. So maybe we're actually finding that the polygraph is not very Scottish rather than not very English. We did submit a number of requests for internal review to police forces, and some of them replied by saying that they did not use the polygraph in an overt capacity, but the meaning of overt or covert use was not explained. And as Kiri said, our research also highlighted a pilot that had been carried out with individuals suspected of committing an online sexual offence, so not with offenders, and also the use by one police force of a polygraph test as a bail condition connected to a community sentence, again different to the use of the polygraph currently governed by the Offender Management Act. So following this freedom of information research, we try to classify the arguments that proponents of the polygraph rely on, and we've classified them into these 6 categories. We won't attempt to talk about all of them, but we will try and summarize 3 of these arguments. The utility argument I'll come on to, but just to summarize the other arguments. The corroboration arguments is the argument that a polygraph test result is just another piece of information to be taken into account. The non-oppression argument says, well, despite the test, an offender remains free to choose whether to disclose information. The containment argument is one that's put a lot that evidential concerns are not really applicable to concerns in a probation context or an investigative context. Expertise argument is the one that polygraph practitioners are very highly regulated and highly trained. And convention compliance is the argument that the government has put on a number of occasions, that even if human rights may be engaged, any infringements can be justified. So the utility argument itself, I think, really pervades everything about the polygraph and pervades all the other arguments themselves. And this is one which justifies the use of the polygraph by saying that it's only seeking to prompt new disclosures from offenders that might not otherwise happen. And evaluations of the polygraph have really been designed merely to test whether that happens or not, despite disclosures not being the end in themselves in many criminal justice contexts. The evaluations based on utility don't address the validity of the polygraph or its overall impact on objectives and human rights principles. And it's quite worrying now that we still see the polygraph being touted as able to detect truth and therefore whether or not to trust statements that are being made. And this is particularly the case in the counter-terrorism bill, where the polygraph would potentially be used to detect whether a terrorist subject to an individual subject to a TPEM, a terrorist prevention investigatory measure, is complying with the other conditions. So I'm going to pass back to Kiri now.
Right. For the next argument that proponents of the polygraph and the government keep repeating, we would like to mention the following. For those among you who are not familiar with the ins and outs of the polygraph interview and the procedure, I think it is important to highlight that it is the document that introduces the so-called polygraph examination instructions, the PEI document, that is important. And according to paragraph 2.7.4, an offender who has failed the test, and this is what they call a DI. DI is the abbreviation for deception indicated, will be given the opportunity to explain the test result in the post-test phase of the examination. So talk is about opportunity and the freedom to do so, and some detected deception, although it is a scientific fact that the polygraph cannot detect anything, that it has not the capacity to detect in a reliable way anything. But still, the polygraph examination instructions talk about the DI, so the indicator of deception, and the opportunity to explain the test. And this is another opportunity, the document says, to disclose information. So our feeling was at the very beginning that the use of the term opportunity, as evidenced above, distracts from the fact that the polygraph test is calibrated towards extracting confession statements by instilling fear of detection. Now, please do remember that the polygraph interview is, unlike the routine visit to the GP or the dentist, a fairly lengthy process, which typically, as far as we can tell from the information that is publicly available, can last 2 or 3 hours. Now, the first thing we would like to point is the obligation of the interviewee to provide an explanation for the DI. which is highly informative for the simple reason that the document itself does not regard within logic of the polygraph, the very possibility of a false alarm as relevant. So a DI is to be equated with a reason to provide an explanation. They do not mention that to the examinee, to the interviewee, that it could be, as it would be with any other device, a false alarm. So the offender, the released offender, the interviewee, has to provide an explanation for an indication which, let us repeat, can on the polygraph's own terms be a false positive, regardless of the validity of the polygraph. And whatmore, if deception is indicated, the offender is not forthcoming in offering an explanation, then the document says a sound guiding principle is to, I quote, address the issue head on with the offender and try to verify it. So, and challenge the interviewee head on, as the document says. And this shows that this is yet another way to gain leverage, to put the interviewee under pressure and make some adverse statements, make a confession based on some pseudoscientific outputs. So this deception indicated. And this is something we know from the 18th century and Beccaria's treatise on crime and punishment, that putting people under pressure is not a reliable way of detecting true statements. Now, moving on to the next argument that the proponents of the polygraph bring forward is what we call the containment argument. Very briefly, it states that concerns around the use of the polygraph from a criminal evidence perspective are not applicable to use in probation or other contexts. So whatever happens in the polygraph interview room stays in that context, so the probation context. Now, this is not accurate. Let me give you a typical scenario with which the UK government advertises the use of the polygraph. I quote, J is a sexual offender, and J was subject to a mandatory polygraph testing as part of his release. During the polygraph examination, he denied any contact with children, the government says, to advertise the polygraph. The test revealed he was attempting to be deceptive. The test was run a second time and still produced a deceptive result. The polygraph examiner contacted the offender manager, who immediately, in turn, contacted the police. And there goes the containment argument. So, first of all, a few points we would like to make is no polygraph results could ever reveal anything, let alone that the interviewee is, I quote the government's document, attempting to be deceptive. The polygraph device is a pseudoscientific device, is what we call zombie forensics. Secondly, this scenario exemplifies that the government pays lip service to the use immunity enshrined in Section 30 of the Offender Management Act, which says that whatever happens in the polygraph interview context will not lead to further legal proceedings. So it will not allow the CPS to press charges. Now, the problem is that the offender manager, as we saw, can inform the police about the DI, which we repeat has no scientific validity or no scientific basis. And so there are no clear rules about what a DI can and cannot be. So it shows us that the polygraph examiner could just name anything a DI, a deception indicator. And of course, the police will then be able to issue a search warrant and secure further evidence, which will in turn lead to a prosecution and to criminal charges. The problem is that according to PACE, we need for a search warrant a reasonable grounds. And we don't have that with pseudoscientific devices. The second main issue, and with that I come to the end of that argument, is that the use of the polygraph jeopardizes the unity of the criminal justice system. But the thing that we cannot declare admissible in the criminal process can be used in the context of probation. And we're not implying that these are the same contexts, but there is still a core minimum, a common denominator among these principles. And among these contexts, and these principles are rationalism and the respect of human rights. And please keep in mind that although we don't have time today to discuss thoroughly the human rights implications, a core principle in Article 5 and Article 8 of the Human Rights Convention is the protection against arbitrariness. The problem is that with the deployment of a pseudoscientific device that is only a Trojan horse for oppression, is just a means to put the interview under pressure. There can be no standard way to conduct this interview. So arbitrariness is built into the logic of the polygraph interview. So that's all I had to say about the containment argument. I hand over now to Marion again.
Thank you. I'm just going to make some final comments about the expertise argument, which is one that we hear a lot, and recently by the government claiming that polygraph operators are highly trained and their powers are carefully managed and overseen. However, what we found was little or no transparent or independent data to support that assertion. The Polygraph Rules 2009 that are linked with the Offender Management Act require operators and also supervisors to be trained by the American Polygraph Association. This describes itself as the leading professional polygraph organization in the world. However, its codes and standards really have no legal or regulatory status in the UK, and they're effectively the equivalent of the polygraph industry marking its own homework. Despite some polygraph operators being public servants, our view is that assertion of American Polygraph Association processes in the UK criminal justice system can't be quality assurance, and certainly not independent oversight or management, especially as commercial interests may be in play in respect of those actually responsible for setting the standards and influencing legal developments. So just to conclude, our paper, which is forthcoming in the Journal of Criminal Law, argues for an urgent moratorium on any further use of a polygraph and independent and public scrutiny and regulation based on legal principles rather than unsupported utility. I think we would argue that there is a lot of attention on AI and machine learning at the moment and its implementation in the public sector. But our view is that we should be equally concerned about the growing use of the polygraph within various aspects of the penal system and its potential further use in investigatory processes in other contexts as well. So thank you very much.
Thank you both very much. That was absolutely fascinating. Perhaps you could release the screen. Yeah, thank you very much. Now, a couple of comments before I hand over to Bethany. Again, way back nearly 40 years ago when I dabbled in criminology, I did a research paper on forensic hypnosis and reached somewhat similar conclusions. Well, even stronger, I would say, that it was not just a bit flaky, it was absolutely terrible as a tool for police forces and others to use. But not surprisingly perhaps, it continued to be used for many years. And one thing I'd be interested to hear is whether you're aware of any police force anywhere in the world that is still using other zombie forensic tools like hypnosis. But I'll leave that till the discussion. One other preliminary comment, though, is polygraphs are now so widely used around the world that there's a lot of guidance available on the internet. Should you think you're about to be subject to one, there are YouTube videos. So, for example, how to pass a lie detector test and prepare for it. And so they tell you the classic questions such as, have you ever stolen anything? There's a sort of rule book the police use of these are the questions to ask. And you should not say never, because you will fail. You should say, I stole apples from the neighbours when I was a small kid. And this, of course, is the whole Theresa May meme. If you're asked on television, what's the naughtiest thing you ever did? Don't say, I never did anything naughty. Say, oh, well, I did run through fields of wheat, as a child. A wonderful meme, by the way, lots on Wikipedia and elsewhere about that. But Bethany, I want to hand over the floor to you, please, and I want to hear your frank and as provocative as you like feedback.
I'll do my best, Christopher. Thank you so much, all of the presenters. I have really been looking forward to this panel. I am not unlike Christopher here. I don't have a past life in criminal law. But there does seem to be some really, really important issues raised, and I'm going to go. I'm going to work my way backwards. And so on Mariam and Kiri's paper, I think everyone would share the concerns that you raised about the use of the polygraph in the penal system, and of course the potential for its expanded use. But maybe to be devil's advocate, would you support the use of the lie detector if it was accurate? So in the US, there is the development of EEG and functional MRI-based lie detection tests that examine the brain. So rather than measuring bodily markers such as blood pressure, which is what the polygraph does, it looks at the cognitive neurological responses to certain stimuli. And so far, there's I think around 90% accuracy being reported. And of course, along this, there will be a huge industry. And so I've in mind here, when I ask you that question as well, Jamie's presentation on the duty, the positive duty to prevent further harm to victims. And also, once victims have recorded a crime, and also prevent crimes from happening in the first place. And I wonder if this makes you feel uncomfortable, the prospect of there being brain reading technology used and relied on with high accuracy in the criminal justice system. If this makes us feel uncomfortable, is that because there are rights engaged here? So you mentioned Curie Article 5 and 8 specifically on the arbitrary point, but also is there an element of mental privacy of those perpetrators or would-be perpetrators, because presumably a lie detection technology with that level of accuracy would be used or could be used to detect crimes that have been committed, to try and identify who the perpetrators are, but also crime prevention. And on this point, I want to then pass it to Jamie. So do you, Jamie, think that given the positive obligations you set out for the purpose of victims, protecting potential victims, would such an accurate lie detection test be not only possibly justified, but also possibly required on the basis of the positive duties you set out. And of course, there's a whole realm of other areas of neuro law which are in development right now. And further on Jamie's presentation, a little bit more, could you just elaborate on what you mean by the would-be victims of gender-based violence that you talked about on slide 9? Because you talked about the tools that would predict risk of victimization, and I wondered about how that would work exactly, and also about the social context and the complexity around the lives of not only perpetrators but victims. And of course, you know this from your own research on Clare's law, and how it hasn't always translated in the way that it would be hoped to translate, where people might be empowered by this information, but doesn't always mean that they will act on that information and leave a relationship with someone who has shown to have a violent past. And also issues around, are there issues here around consent for the use of information which is fed in to try and identify and protect would-be victims? And then Marion, Jamie and Tom, I really enjoyed learning about this West Midlands Ethics Committee. I think it's a promising model. And I just wondered, firstly, in your slides, you reference one of your interviewees, I think Marion, from your interviews, that said something along the lines of there's no single regulatory voice. And I wonder if the West Midlands Ethics Committee, and whether if one was to be set up, a national ethics committee would add to a kind of oversight overload for the police, who are rightly so, necessarily so, held to accountability in lots of different forums. So through internal complaints, through the courts, through budgetary committees, through strategic boards, through community advisors and so forth. So just wondering about that. And then finally, if I have time, I was wondering about the relationship between the committee as monitoring the use of the local police forces data lab, and the way in which the data lab is using this information in order to detect, prevent crime, and in areas of really big importance like human trafficking, domestic violence and so forth. And picking up on the point that Tom made about a sense of there being a social and collective ownership over, our public institutions, but also the ways in which our public institutions operate. And so I'm just wondering about whether the ethics committee can facilitate further engagement with communities directly affected by the use of that data. So that's people living in areas vulnerable to specific types of crime, or people who have a history of criminal behaviour, or people who are at risk of being sucked into criminal behaviour. What's the relationship there between, or how does the committee facilitate a relationship between the use of the data in the data lab and those communities? Or rather, is it not the job for the ethics community to try and do that?
Fantastic, Bethany. That was absolutely brilliant. Great comments. good cross-examination, lots of questions. The only problem is we've got 5 minutes on the clock. In theory, I'm going to ask Nora or somebody else whether we have any flexibility to carry on for another 5 minutes after that or not. Perhaps you can put that in the chat to me in due course. But let's take those questions in the order they in the reverse order as you presented them. So can we get some response from Kiri and Marion perhaps first to this point? What if, hypothetically, let's just accept this claim of 95% accuracy. Then I think this is also for Jamie, because the similar point was really put to him. Will there be a point where you really have a duty to use these kind of forensic techniques?
I just wondered, Chair, if you don't mind, could I go first? I know I already mentioned second, but it's just I have to leave promptly in 5 minutes. So I'll be very quick as well. So I think that there would be a duty, I think, because as I've started to understand things, there would be a duty to use technology if the accuracy sufficed to do it. If people are interested in that ethical debate as opposed to a legal one, because it's kind of non-jurisdictional, there's an excellent last chapter in a book called An Anatomy of Violence by Adrian Raine. And there's always a danger of only reading one book about something and then thinking you understand it. But it's a book about like neuroanatomy, brain science, and links to violence. And the last chapter looks at, based on all the presumptions, if you like, of accuracy growing over time in that use of technology, what on earth do you do with things like interventions with young people when you can see that they have the neurological development track or train of someone who as an adult would be a very violent person indeed? Like what do you do with them? And there is no answer to that. There is no easy answer to that, but it will come, as in we'll have to have an answer for it according to Adrian Raine. As a society, we'll need to develop one because the technology is going to get so good. But Bethany, thanks for your comments about my paper as well. And I know I'm going out of order a little bit here, Chair. It's only because I've got to shoot off in a few moments. But I think I might have misspoken when if I used the phrase would-be victims. It was probably meant to be like possible victims or likely victims or something like that. But the way that you've then phrased that question to me, Bethany, is really interesting because you are potentially talking about people whose partners would have an intervention from the police, who, as you said, would not necessarily consent to that. They might be risk scored as a relationship very, very highly, and yet that's not necessarily a welcome intrusion from them. And you're quite right, that is a strand of debate in relation to Clare's law under the right to know strand, which is like the more proactive strand. And again there, you're talking about is respect for a person's consent. Is that an Article 8 duty? Is that about respecting their integrity of respect for someone's private life? But if the harm that could be done to them is Article 3 grade harm, well, we know how, if you think about these things hierarchically, what that translates into. That translates into intervention without consent, which is why prosecutions ultimately can take place without the consent of a victim around domestic abuse. So I know that's a really speedy pair of answers, and I'm really, really sorry, everyone, for going out of clearing. But I hope that's done a half-decent job, Bethany, because those are very good points you raised.
Jamie, that was actually very helpful. Thank you for intervening. And thanks again for your excellent presentation. We look forward to reading the paper. So let's keep going. And I'd like to see if Kiri and Marion want to come in quickly on that same point about the duty to use some of these technologies.
Marion, let me quickly make 2 points. If you remember, I was careful enough to make clear that the polygraph as a device has to be embedded and make sense only from the point of view of an obsolete paradigm in psychology. This is called introspection, which is the idea that there is a physiological correlate of deception, love, friendship, that we can detect something in our physiology, whether it's heartbeat or some neurological activity in the brain or whatever. Now, because this is an obsolete paradigm, this has to take with it at its grave its offspring, the polygraph. So we cannot detach the polygraph from the framework that gave birth and rise to the polygraph. As regards the question for the accuracy rates, the hypothetical scenario, here's my problem, and I think this was also Christopher's point, coincidentally. In these experiments, participants are asked to imagine that they have stolen something in the room and then go on to answer, did you steal the pencil? Well, this could be for them sufficient, but in our universe, this is dissimilar with anything that happens in the real world. This is experimentation with the wrong Guinea pigs, if I'm allowed to put it like that. There's nothing resembling the situation in a courtroom where people have real stakes, real interests, real motivations, and also evidential and human rights. So I don't see, first of all, the plausibility of that hypothetical scenario, but also only if we reduce the complex scenario of the criminal justice system to an oversimplified scenario, then we could start imagining if we would have accuracy rates that are high or not high. But again, since there's no validity in that, I would not be willing to answer that hypothetical scenario.
Okay, thank you very much. Well, I have a special dispensation from Nora to carry on for a little bit. But so, Bethany,
sorry,
yes, do come back.
Can I just make one point? It's not solely hypothetical because the tests have been done and they are showing very, very high accuracy rates. But of course, they're not being used in this country. But I just wanted to make that clear. And if it's of any interest, I can show you. I can share with you some of the research that I found on it.
Just to make clear, we are aware. We have this in the references in the paper, but all I'm trying to say is that they are not realistic, and the projection of these experiments to the real world is, in my mind at least, not plausible.
Yeah, I'd just like to say, though, it would be very interesting to see some controlled trials where you're able to assess objectively how good humans are at assessing honesty or dishonesty in responses to questions and compare those to the machines. Because this is a huge problem right now, I think, in the debate about use of machine learning and other narrow AI tools, is that it seems to be that machines have to massively outperform humans. And it turns out that humans are actually not very good at doing a lot of these things themselves. And in the criminal justice context, many of you will be familiar perhaps with a study of parole board judges in Israel, where somebody went to the trouble of analyzing the reasons given by judges for parole decisions, and then they compared that to all the objective criteria that they could find. And when they mapped all the variables, controlled for everything possible, they concluded the only statistically significant things were how long is it since the judge had breakfast or lunch, which is, if indeed that is the case, that's an example of almost certainly subconscious bias on the part of a human. And if you ask the judge to give their reasons, they would give you, reasonable sounding reasons, I'm sure. But if it was possible to get, as Bethany says, to this 95% accuracy benchmark for the machine making the assessment, then we'd have to ask ourselves, are humans really any better than that, or are they possibly significantly worse than that? Okay, so the last response, I think, was needed to the point that Bethany made about oversight overload. And I'd like to mention an interesting question that Julian put in the Q&A, which Tom has already responded to in writing. So everybody should feel free to look at that, which raised a similar question, actually. Is there risk of further confusion and ethical arbitrage if you bring yet more players into this space? And I mean, we already have, I've lost count, more than 100 data ethics policies, guidelines, statements from various bodies, some of them global like OECD and others. And we also have a lot of regulators, not just in the UK, but around the world, attempting to regulate activities in this area. So is the answer really to have even more people trying to manage this process? So that's really one for Marion or Tom.
I've got a couple of comments I can make on that. I think Julian's comment and Bethany's comment, that super pertinent and relevant, and there's things to be worked through. But I do think there's cause for optimism on it. There's no doubt an awful lot of different frameworks going around, and that does complicate and confuse things, although there's huge commonality between them. Lots of key principles you'll find in nearly all of them, and they're all really important. What we really need, though, is people to kind of get their hands dirty and do that oversight. Now, Julian, in his comment, raised a few different kind of bodies who are all extremely relevant, but at the moment are all doing slightly different things and playing a slightly different role. And the one reality we've got to deal with right now is there is quite a broad consensus, actually, that in policing at the moment, there's lots of people beginning to use AI or explore the use of AI in policing, but there isn't enough scrutiny over that use. There's a lot of consensus in that, even in your kind of policing circles. And the police do have to face many different regulators and inspections and oversight bodies, but that is the price to pay for the very significant powers they're given in society. And most senior officers I work with, they do find it tiresome, it is difficult, but they accept how important it is. And I think what we've seen with the ethics scrutiny we've given is it's typically made the police's job easier in the long run. So we've seen, and Marion touched upon this before, some really direct improvements to some of the particular technology projects they're looking at. But also, if you get this wrong, and at the moment there is a real risk some forces will, if we don't find a way to get the hands dirty job done, you're going to have legal challenges, which some might be successful, that would ruin a project, or you might have a tech which leads to injustices, which again might lead to legal challenge, but the injustice alone should be enough to worry. Or we might have police forces feeling that they have to drop technology altogether or have insufficient confidence. If we let police forces, set up their own data scrutiny bodies all over the country, I think there's a real risk there won't be sufficient expertise across all, to make all of that up. But I think you'll actually end up getting an awful lot of duplication. And so I think the key is to make sure the different bodies focused on this, again, some of the ones mentioned in Julian's comment box, is that they are all working together over a shared agenda. And the final point I'd make is we've actually already started on the scrutiny of national projects, which are being led by West Midlands Police, but on behalf of other police forces. And so, in a sense, we've already started, and we're playing a different function that I think will complement some of the other bodies. Over time, when we work through this kind of emerging complex set of issues we've got, I think clarity will start to appear. Things often start complicated, but hopefully in 20 years' time, we'll have a much, much more kind of stable understanding of how AI should be used in the public sector.
Can I just add one comment to that? I'd just like to say that I think that what distinguishes with the West Midlands approach is that we have tried to follow very much the approach that was started by the National Statisticians Data Ethics Advisory Committee, which is very much an approach of doing ethics in a context which gives a wide scrutiny based on a wide level of expertise to the projects. And I think that's what distinguishes this approach from a lot of other approaches, and which could give it that power at a national level to give, as Tom says, the police forces the confidence to move on with technology, as opposed to be, hiding it or not doing it at all, or potentially creating a large number of issues. I mean, I do think things like the expansion of technologies around, the ones that Bethany was mentioning are exactly the sort of thing that should be given that level of scrutiny, because of, the issues that could be created by putting a technology that analyzes somebody's brain or voice or anything, eye movement, into a context where, really crucial rights are at stake on the basis of utility, basically.
Thank you. I think we do need to take a break. We're conscious, because of that parole board case I mentioned, of the importance of bio breaks, or people tend to make mistakes. But the good news is the panel that follows, Julian and Michael, I know, have been listening into this discussion. And so if they have further things they want to say about this topic, there will be an opportunity when we reconvene at 3:15. But for now, I'd like to thank all of our speakers in this session and our discussant for a really interesting panel. Lots of fascinating content, lots of food for thought and provocations. I'd also like to take the opportunity to thank Nora and everybody else in her team at the Information Law and Policy Centre for putting together a great conference. In difficult circumstances, we'd love to be meeting in person, but I really think you've done a great job. And on behalf of everybody who's attending, I'd like to thank you for that.
So I will start and welcome everybody back, and good afternoon to you all who are joining us, or everyone who's been with us today and yesterday. I'm delighted to be chairing this fantastic panel, and they're all going to be sharing their specific insights and expertise with us on their particular areas relating to AI and the rule of law. But as you just heard from Lorna and our other panelists, they're also going to be sharing their insights on key themes and issues that have arisen over the past 2 days, and general internet coverage may also topic we also discuss. So I'm just going to go through all of the introductions now, everyone, and then the panelists will speak in turn. Is Dr. Michael Veal. Michael is lecturer in digital rights and regulation at the Faculty of Laws, University College London. He specialises in the intersection of law and policy, emerging digital technologies and human-computer interaction, publishing both legal and computer science scholarship. He has authored and co-authored reports for a wide range of organisations, including the Law Society of England and Wales, the Royal Society and the British Academy, and the Commonwealth Secretariat. His research has been covered widely in all major UK media outlets and also internationally. Michael also sits on the advisory councils to the digital rights organisations Foxglove and the Open Rights Group, and he is also a member of the working group of the Ada Lovelace Institute's Rethinking Data programme. Between 2019 and 2020, Michael was Digital Charter Fellow at the Department of Digital Culture, Media and Sport. Next, we will have Bethany Shiner. Bethany is a lecturer in law at Middlesex University, London, and also an ILPC research associate, I'm delighted to say. Beth has published research on the application of data protection law, electoral law, and direct marketing regulations to political microtargeting, She has argued that proposed reforms to tackle the problem of abuse of personal data for the purpose of online political campaigning and gaps in electoral spending laws have been inadequate. She has submitted written and oral expert evidence to several parliamentary committees, and her calls for reform have been cited in the all-party parliamentary group on electoral campaigning transparency, in its final report of Defending Our Democracy in the Digital Age, and by the House of Lords Democracy and Digital Technologies Committee's final report on digital technology and the resurrection of trust. And last but not at all least, our final panelist and discussant for this afternoon is Dr. Julian Hubbard. Julian is an academic and politician. He was the Member of Parliament for Cambridge between 2010 and 2015 and served as the Lib Dem spokesperson on Home Affairs, Justice and Equalities, as well as serving on the Joint Committee of Human Rights and the Home Affairs Select Committee. He was named ISPA Internet Hero of the Year 2012 for defeating the proposed Communications Data Bill. He is now the director of the Intellectual Forum, a new interdisciplinary centre based at Jesus College, Cambridge. He is also a director of the Joseph Rowntree Reform Trust, deputy chair of the Cambridgeshire and Peterborough NHS Clinical Commissioning Group, and a member of the Home Office Biometrics and Forensics Ethics Group. He was also the first chair of the panel of independent reviewers of DeepMind Health. In terms of format for this panel, each panelist will speak for approximately 10 to 15 minutes. This will then be followed by some discussion, and we would really welcome any comments or questions from attendees for this section of the panel.
So I want to reflect on AI and the rule of law more generally and highlight a couple of grouped challenges that I see that I think others are not highlighting enough in the trajectory of these technologies and the business models that surround them and how they'll interact with their future regulability. So when we think about AI and the rule of law, as Lorna said, there are lots of different frames that we end up thinking it through. Sometimes we might think through a platform frame, sometimes we might think through a data protection frame, and those really do constrain both the problems we see and the solutions we have. One frame that I think we ought to be looking at is the way in which effectively the political economy of the delivery of AI and the structure of the markets that are providing these technologies. And I'd posit that they're really emerging as a form of servitization. So what we find is that AI is effectively being delivered as a service in many different contexts, and that's enabled and facilitated by many important factors that I think as legal scholars we need to pay more close attention to. So what do I mean by servitization? Well, many of you will have seen that that more and more services are based on a subscription basis. We don't own things as much anymore. We don't own software. It doesn't come in a sort of shrink-wrapped box anymore. It's paid for by the month and constantly updated. And even hardware or household goods can now be paid for by the month. And we see that as being an attractive business model for provision of those services. So when we look at servitization, we can look at the recent case of bridges as well. So the bridges case, as far as I can tell, when we're looking at the facial recognition technologies deployed by NEC, these were also examples of servitized technologies. These technologies were provided, updated regularly. They were treated not as a piece of software that the police or any police force using them could own forever and use forever, but they were working with servers and infrastructures that were borrowed and software that is expected to change over time. And we saw that the court in that case, the Court of Appeal was quite concerned by the lack of scrutability, the lack of ability for the police force in this case to check the algorithm, to understand it, and had some harsh words to say about that towards the end of the judgment around the way that could constrain public actors. And you could probably read forwards from that, admittedly obiter section of the judgment to suggest that this the Court of Appeal may not look very favorably on public sector algorithms which are unable to be examined. And that's worse in a servitized context, because in servitized contexts, predictions are often delivered through an API. In a black box system, you feed input and you return an output, and the black box can effectively change from day to day. Not in machine learning is self-learning. People make too much of the idea it changes from one day to the next as being a problem for regulability. The problem is the people who know how it changes and when it changes are not those who are typically using it or have prime legal responsibility for it. And you're in a public sector organization, the public sector equality duty, of course, which Jamie talked about and Lorna just mentioned, is a non-delegable duty in this case. So this I think becomes an important aspect where servitization makes it difficult for regulators and also anyone to challenge a system, anyone to really gather evidence on the fact it may be discriminatory or may be performing in a problematic way. Creates problems for what we assume are ways to highlight problems in these systems, like whistleblowers and so on. These people don't always have the same access to undertake the kind of lay policing role that we maybe assume they do. So another thing that amplifies this problem in a consumer context rather than a public agency context is control of end devices by platforms. So when we have servitization, this is added to the fact that we don't control operating systems anymore, and particularly driven by mobile devices, we can't see or have any influence really on the exact software that is running on an iPhone or an Android device in the same way that we can on a PC. We see that Apple, for example, are taking more and more moves to make their computer offerings more similar to their phone offerings, changing their chipset to allow the new computers to run iPad apps, trying to authenticate all software with Apple servers before it's allowed to run. So you have a lot of control over these end users' devices, and this means that individuals can be put into, can be coerced through AI systems that they can't control whether they're running or not, even on their own devices. So we see a movement there, which we obviously saw in the online sphere with platforms online, but it's coming closer to home, it's coming closer into our own devices, and it's coming closer to the sensors that perceive our environment. It's no longer going to be stuck behind an app or a web browser where there's some distance. It's really on our devices, in our homes, in our applications, appliances rather, and therefore it's even closer to us. And that links to the last point around servitization, which is perhaps the most worrying part, which is the move to use privacy as a get out of jail free card to do what you like with AI services. What I mean by this is, and some of you may have heard me talk a bit about this before, is the growth of private computing. So, and Chris Millard, for example, knows about these areas too, with the growth in the cloud environment of secure enclaves inside clouds, but also other techniques like differential privacy, secure multi-party computation. What these effectively allow you to do is to take individuals' devices with very, very sensitive personal data on them and have an orchestrating actor that controls the software they run, be able to get these devices to talk to each other. They just send gobbledygook between each other, really. They're just sending encrypted messages that they can't open on each side. And the result is an aggregate, a data aggregate, which could be a machine learning model or an AI model, or it could be information about the world that might not be considered personal data under European law. The problem we have here is that it means that the organizations, the platforms that start to control the end devices now no longer can just coerce you, but can also learn about society while being able to legitimately say they never saw personal data about you. If they were put at gunpoint, given there was a warrant against them, they could not be producing that personal data, and therefore it's all kosher from a privacy point of view, and that's the only issue we should be worried about, so let's all move along here, nothing to see, it's just good business. That's definitely the approach that Apple, for example, are taking, and some other and Google, Facebook are looking to encrypt their platform very heavily because they realize that there's no intrinsic value in them to data because they're not an intelligence service. They don't care about the contents of your messages intrinsically. They care about the way in which that data can be used to personalize, to extract value, to render you legible, to sell access to the things that you see and the things you interact with. And that makes it difficult for the rule of law because it does another thing as well. It makes these systems more opaque to examine. So Lorna was saying as well in her discussion, designers should take more responsibility for what's going forwards and what their products are being used for. In private computation, designers like Odysseus can bind themselves to the mast and not see things they don't want to. You can design a system where there are certain kinds of monitoring that are not possible to do. And of course, we know, for those of us who study internet and platform regulation, that's a very appealing thing when we think about intermediary liability law, because it's premised on the idea that if you don't see it and you're not told about it, you're okay. So the more things you can deliberately and technically distance yourself from and make it difficult or impossible to learn about, then whoop-de-doo, it's again great business. And that's a problem for regulators. It's a problem because to design that scrutiny and to design the opportunities, the regulatory access points to understand if job adverts are being delivered fairly by sex, if political ads are being delivered only by bona fide organizations, for example. All of these things requires those questions to be accessible, and it requires at the point of design for regulators to, before the design decisions have been made, to say we would like to know about those potentially in the future. So it requires law not just to keep up with technology, but to really preempt it before it gets placed in and design those features in. So I find that to be a particular problem. So lastly, I want to end up these comments with thinking about the kind of lobbying game that I think platforms are playing here. And sometimes they're not playing it totally explicitly. I don't think there's a sort of evil room where they all recline, they'll return to and say, haha, we've got a secret plan. We're going to do this and that and the other. But it emerges. And the emergence is a few things. Just like one of the reasons why end user device control is really important to platforms, and they've sold it as important, is for security. We're dealing with a very insecure online environment now, with large automated attacks being carried out at all times, with APIs being used to exfiltrate personal data, and attacks will become more and more automated over time as well, and will require that of a high defense capacity. The platforms sell themselves as saying, here, in our device, we provide a zone of control. We're gatekeepers of what comes in, what code can run, what code can't do, and we make a safe and secure place within that bigger world. So that's the computer security part. But we're in danger here of letting that tension between being able to do what you like on your computer and having some overarching control also mean that we're forced, these companies, platforms, are putting themselves in a position where they are indispensable to regulate through. In areas like fairness, areas like discrimination, areas like harassment and abuse, where AI systems cannot and will not be able to run in accordance with the law unless they are overseen and kept up by a large organization that runs them and delivers them in a servitized manner at scale, because only they have the visibility and capacity to analyze them in that way. And I think that's something that we have to be aware of and careful of. And I don't think we should go for a totally hyper decentralized world where everyone is a super user and runs whatever they want on their own device and it all orchestrates beautifully like Solid or Tim Berners-Lee's dream of the new web. But I think we have to be aware that when we want to create systems that are regulable and fair, and we have other issues like competition law in our mind, other concerns that we want to deal with in the digital environment like power, we have to proactively design an environment that can be regulated and balances many of these needs. And that requires regulators and politicians to have a much more normative vision of what the internet they want is, the structure they want, and perhaps take much more active design decisions and not push them out to companies to take. There's a risk if we say, companies, you make the design decisions, we'll just give you the principles, that there's moral hazard there in the long term, structurally designing power in that can't be removed. And I think there's a role for designers to take responsibility, but we have to be careful by giving them too much responsibility in that way, because without taking some of that into public capacity, because some decisions are more strategic than others in a time frame where politicians and regulators are not always so good at seeing or caring about. So thank you for those chances, and thanks for the conference, Nora.
Thanks so much, Michael. That's my subtle chairing technique, turning on my camera for timing people. I have so much I want to say in response to you and Lorna, but Beth, if you're ready to give us your views, I'll hand over to you, and then I'll keep discussion points for afterward then. Thank you.
Okay. It's a real privilege to be on this panel, and I'm very happy to step in last minute for Meg, particularly given the company. And I just have some very broad reflections from a human rights perspective and from some more specific areas of the use of personal data. And I will keep my comments as brief as possible, because we're probably all tired and we want food and booze. So several of the papers alluded to or seem to directly address issues of autonomy and agency, sometimes in relation to automated decisions we may be subjected to, sometimes in relation to the power imbalances that go with the reliance upon data in the context of us as individual employees or consumers and as political actors, as citizens. And so we see the question of agency crop up in the context of en masse data mining, consent, surveillance capitalism, which was mentioned, which has been mentioned a few times throughout, actually. The use of machine learning in crime detection, prevention, and as Nora was referring to, the shaping of our access to information through fake news and recommendation algorithms. And in response, of course, we turn to data protection legislation and ethical frameworks which have been discussed during this conference, or high-level policy, or the regulation of high-risk products or high-risk industries, or we talk about regulating the use of some technologies in the specific form of analytics for a specific type of public service delivery. And there's been regard as well to, alongside agency and autonomy, to human rights. And of course, agency and autonomy is one of these, founding core principles at the heart of human rights regimes. And so we can talk broadly about the application of human rights standards, and of course to the limitations of human rights law as was discussed in the panel yesterday afternoon, because threats to human agency are widespread, and they cause social changes which we don't always feel we consent to or can do anything about. And so it was observed that what's missing is a sense of collective rights, and collective harms, and of course collective redress. And so in relation to these kind of very broad observations, I just want to talk about one specific human right, which I think is relevant but often overlooked. And the second point I'm going to make is just about different approaches to data. So the Council of Europe's Committee of Ministers on the Manipulative Capacities of Algorithmic Processes has observed that fine-grained, subconscious, personalised levels of algorithmic persuasion may have significant effects on the cognitive autonomy of individuals and their right to form opinions and take independent decisions. And the example of accessing information is quite a clear example. And if this statement from the Council of Europe's Committee of Ministers is correct, then individual autonomy is potentially arguably being undermined on a daily basis, on a global scale. How do we respond? Will ethical frameworks be adequate? I mean, self-regulation is consistent, as we know. The up and down responses of Facebook to political content on its platform is the most recent demonstration of this. Does data protection adequately protect us, given the challenges this poses not only to individual freedoms but also collective and social harms that are implicated? What about the dilution of democratic freedoms? Is our power as citizens, not just consumers, being eroded? And so the right that I think is applicable but often overlooked is the right to freedom of thought. And people in this realm talk of mental integrity, a cognitive liberty, or an intellectual privacy. Others have advocated for new rights to be developed and inserted into treaties to protect our minds and protect our autonomy in this regard. But I think that the right to freedom of thought, contained in Article 9 of the European Convention of Human Rights, and I'm not the only person to advocate for this, actually. Susie Allegre has written about this. Jan Christoph Bublitz has written about this for many years. And I think, and I agree with them, that the right to freedom of thought is there and can be used to protect unmanifested thoughts, which can be tracked, recorded, predicted, observed, and it can protect some manifested thoughts. And yet, the European Court of Human Rights has not been asked to decide on this. It's not been asked to decide on the applicability of Article 9 freedom of thought to these new technologies. And it's applicable in other areas, neuroscience, for example. But I think that it will soon be asked to decide on this point, and sooner rather than later. And the second observation I wanted to make is on the similar theme of deceptive manipulation, which is a term that's been used on at least a few occasions during the conference. And so, despite the GDPR and the Cambridge Analytica scandal, there continues to be an industry of firms offering neuropolitics services, which are about measuring emotional responses and other opinion responses to political content online. It's a huge industry. And the point for me isn't a question of whether those techniques work in shaping the way people vote, but it's about the attempts to do so, whether successful or not. And related to this is, the risk of misuse of personal data. And in Europe, there seems to be varying abilities of political parties to rely on personal data for these purposes. And the Data Protection Act 2018 makes provision for the use of special category data for political campaign purposes. And the ICO guidance on the use of personal data in political forms in political campaigns, is still in draft form. And now that it's published its report on its investigation into the improper handling of personal data in political campaigning by political consultancy firms, related to the Facebook and Cambridge Analytica and the Aggregate IQ investigation. Since it's released this report, we can hope that the ICO will publish final guidance on the use of personal data in political campaigns. But there's something lacking here. And the ICO has itself said that there are systematic vulnerabilities in our democratic system. And as such, it is called for legislation that will provide a statutory footing for further guidance on the use of personal data in political campaigns. So as I said, there's something lacking here in the UK, and the UK's position contrasts with Spain. There was a recent case in the at the end of last year, 2019, in the Spanish Constitutional Court, where we had an ombudsman successfully bringing a challenge to Spanish laws, which provided a broad permission for political parties to collect and use voter data for campaign activities. And it was held that this law was unconstitutional because it violated the right to personal data, privacy, the right to ideological freedom, which we can understand as the right to freedom of thought, linking back to my first point. And importantly, it undermines the right to political participation. And so here we see that there's a clear relationship between data collection, democratic participation, and freedom of thought. And for me, all of these things return to the first thing I said, which was about the theme of a human agency and autonomy. And this needs to be central to our discussions around how best to regulate and establish standards, along with the assessment of risk and harm. Okay, thank you.
Thanks so much, Beth. Julian, whenever you're ready, thank you.
Fantastic. Well, thank you very much, Nora. And it's great to be here and to have the chance to listen to this whole conference for a couple of days. I certainly learnt a lot. I should admit that I'm slightly here under false pretenses because I'm not a lawyer. As possibly Nora knows, I started a law degree and then my first year exams were the same day as the general election. And so I had to make a difficult decision, and I went with Parliament rather than law, and you can decide for yourselves which is the more honourable profession to have gone into. But it's been so interesting to hear about all of this. I've been scribbling notes frantically throughout, and there's lots I'd love to talk about for many things. I mean, just to pick up Bethany's comments just now about political campaigning, I mean, I think there's scope for an entire conference about what's happened, why it's taken the ICO so long to give proper guidance, And what we could talk about the impact of the segmentation that comes from use of that data on the public sphere, on public discourse, on polarization. We could talk just about that, but I'll resist that urge for now, at least. I want to talk about a couple of other issues. And in particular, I want to talk about the difference between theory, as we've talked about in some of these papers, and practice, which has come through in some of these. And obviously, as I'm sure you all know, in theory and practice are exactly the same, but in practice, they're completely and utterly different. And so I'm always interested in how we actually try to do things legally and ethically correctly in reality. And so I've been working on this in a whole bunch of different contexts, some with governments, some with other groups, but particularly with a range of technology companies, both large and small, to try to think about some of this. I should say Nora's been commenting on the side to some of the panelists. We welcome all scholars, not just lawyers. And as an erstwhile politician, I'm glad to count as a scholar. But so, for example, I worked with DeepMind Health. So we were trying to pioneer a new form of ethical oversight and governance to find out one way to check whether AI was being done appropriately and whether the whole company was set up appropriately. I can talk for ages about that as well, but the idea was we'd have an independent set of reviewers with free rein and no confidentiality rules to find out what was actually going on inside that fascinating company, make public criticisms and proposals for improvement. I'm not going to go on about it, but do have a look at the reports that we put out, because I think they were quite interesting. But it also links in with the tension that's come up quite a few times, right from Tim CJ's talk right at the beginning and many others, Marian's quotes from Hildebrand and so forth, about the tension between ethics and law. And some people always advocate for law and regulation. And sometimes that's obviously important. There are things which we should say are not okay. But there are real challenges with law and regulation. It's often slow to develop, and it relies quite heavily on clear definitions. It's not great to have laws with large grey areas. And that causes problems. I mean, Michael just touched on one of those issues, which I've talked about quite a bit, which is even just the definition of personal data has weaknesses. Data on a single person household is personal, but loses all of that protection as soon as there's more than one person in the household. That gives very odd results where the law fails to give us what we think ought to be important. So that's the challenge with law and regulation. But then on the other side, there's ethics. And so some people are wonderfully in favour of ethics. And I think that's great, as I'll come back to. But there are challenges with an ethics-driven approach as well. So we've already talked about the well over 100 different ethical frameworks, the risks of lack of clarity in that. And a theme I certainly keep coming back to about ethical arbitrage, where people simply pick and choose until they find a report from somewhere which says that something is a good way to work. There's a real problem with that. There's also a backlash which comes, particularly, I have to say, from lawyers, that say, look, this is just ethics washing. That talking about ethics, when you see a company talking about ethics, what they really mean is, let us do whatever we like, don't have any laws, don't have any regulations, let's make it all soft so there's no real controls. So I think there's a bit of a tension here. And I think we need to make something of both of them. So in my mind, at least, law sets the minimum standards for the worst performing organisation. It says you may not go below this threshold, but it doesn't say anything about what you can do that would be better. Ethics, on the other hand, is trying to reach improvements for the best performers. And ideally, you need to have both of them to get the best outcomes that you can have. Neither one can substitute for the other. And that, to me, is really important. We have to have both conversations. They're not competing. They have to build on each other. And the question I want to talk about for a bit is how we get ethics to really make a difference. In particular, why should organisations seek to do things ethically? What are the incentives that we can provide as society that mean that there's some reason to do that? Because we've often spoken, I've seen it not entirely through this conference, we've seen some exceptions with some of the policing pieces, but there's been a sort of implicit assumption in many of the talks that a lot of the people and the organisations who do things with AI are bad actors that we need to control in some way. And that's true in many cases. There certainly are bad actors. But what do we do if they are actually eager to do better? And I'm not naive about this. Powerful organizations, particularly tech monopolies, can do bad things inadvertently, even if they mean to do good things. And of course, just because an organization is led by somebody who wants to avoid doing evil doesn't mean it won't be doing evil next week, next month, or next year. So how do we have an incentive? So with DeepMind Health, our approach was to earn trust in the company by trying to transparently demonstrate trustworthiness, by having a very risky approach to transparency, where, for example, we commissioned our own independent legal advice that they paid for, but they had no control over. We also commissioned an independent company to do a security assessment of all of the code they produce, to actually go through it all, the coding environment, the physical security, everything. And then we published everything that was found, including all of the weaknesses and the criticisms. Now, very few companies do that. That's quite a bold thing for any company. It was, I think, the first time an alphabet company has allowed it to happen. And the idea was that if companies had an incentive to be open and honest where they weren't great, where there were small errors in code, and none of them, as I said, were significant, that people ought to trust them more than companies that wouldn't engage with that process. I spoke to another competitor, Microsoft, and said, would you consider doing this? Would you consider allowing an independent audit of your security? And they said, absolutely no way, but we don't need to because it's completely secure. How do we have an incentive to go for the company that's risky and open and transparent and not the ones who just assert that things are fine? But it didn't really work. For a whole bunch of reasons, we didn't have enough time, we didn't really get the traction to really transform the way that works. Which still leaves the question open to me, how do we get people to do good things? So let me give another example. I advise a company called Sparks. They're based down in Devon and Exeter. They work on EdTech. They do maths lessons, they do homework. They're actually a fascinating, rapidly growing company. And they really are committed to trying to do the right things ethically and actually also on research evidence. Both of these are really lacking in the EdTech sector if you've ever played in them. There's a lot of very quickly produced products. Let's get this out into the schools. Let's worry about whether it actually works later on. Let's not worry too much about how we control the data, what the AI does. And I may have, drunk a bit too much of Kool-Aid, but they are committed. And one reason is because they're asking me, how do we try to make sure that we do the right thing on these cases? So I'd like you to join in and just think, let's imagine you're running a company in this space. You essentially have to work out what to do. You could do the minimum, avoid any blatant legal breaches, but take the risk that probably if anything goes wrong, the ICO won't actually do anything. They're not interested in that. We can use legal tools about that one. Or you say, look, we'll hit the legal standards, you minimize exposure to your legal risks, and you take some impact on your product perhaps, but your aim is to avoid downside risk. If you want higher ethical standards, you want to do things well, better than the legal requirement, that's going to have downsides in the timescales and the scope of your product. But what's the upside? There's some soft things, there's maybe employment is easy, you'll get good people, there's reputation, but do we actually get those from doing things ethically well or by employee benefits, PR and so forth? How do you incentivize a company to get that right? I'd like to say that products are better if done ethically by design. That may be true, but constraint theory suggests that that's not going to be as simple to make. So how do we incentivize companies and other organizations to be ethical? Can we play around with procurement rules so that you set higher standards than legal minima? Could you have charter marks for ethical behavior? But I think one of the key questions that we have to think about is if we want organizations to really be ethically driven, to really work above the legal minima, there has to be some way that they benefit from doing that. Because if not, their rational course will not be to be ethical in the way that we'd like. Thanks.
Thank you so much, Julian. And also thank you so much for wrapping up in terms of timing perfectly. I do apologize in terms of where we have landed regarding time because we literally have 1 minute remaining. So All I can say for this panel is that there was just some really fascinating insights and conclusions drawn from the past 2 days. And if it is at all possible for the speakers of this panel to perhaps stay on so that any of the other attendees could, well, actually not to stay on, but we have a Meet the Speakers session that's taking place between 4:30 and 5:30. So if any of you have the time to join us there, perhaps we could continue this conversation. But of course, I completely understand if you don't, but we really have just run out of time in terms of having any discussion now. So before we do that though, there was a question put in the Q&A section that I would like to raise to the panel before we conclude and then pass on to concluding remarks. And it was specifically for Bethany, but if everyone could give a quick response to it, that would also be fantastic. And it was regarding whether in the case of the deployment of social robots in a household, whether an individual's specific consent would be sufficient in that particular context. So I'm going to leave you with the challenge of if you could possibly respond a comment and insight to that particular question that was raised, and if you could give any concluding thoughts yourself, all within a minute or 2 minutes each, and that way we're only running ever slightly behind for the closing remarks that will be delivered shortly. Could we possibly start with Bethany and then whoever would like to step in next? Thank you, Bethany.
Sure. I mean, this is a boring answer. I suppose it depends on what the robot's there for. Is it providing, partly, is it providing health and social care? There are specific rules around that within the GDPR and within the Data Protection Act, and they're meant to be specific protections around there. But I also want to just say, I hope that when I get old, I don't only have the option of a robotic nurse. I hope that's not all that is available to me. And the development of all of these new technologies is really interesting in the context of a national health system which is struggling to fill all the places of nurses and whatever that are required. So will this be another example of technology filling a gap, a self-made gap in a public service provision? But Lucas, I've already sent you a message that I'm happy to correspond with you further on this point. I'm just mindful of time as well.
Thank you so much, Bethany. So who would like to go next? Michael.
I'll just say very, very quickly. I think that if we so in this case, like other cases, we think about the individual incentives at that moment of time of a company or an organization, but we have to think structurally about where they play with a larger role over 1 year, 2 years, 5 years, 10 years for the world we want, the technology we want, the internet we want, all these kind of things. It's very tricky because that immediately hits the initial problem of asking politicians to look over a larger time horizon, which of course we find in other complex areas like the environment really struggles. But it also hits the problem of they and we don't really know what we want this to look like. So we want to kind of adapt over time and accept new innovations and changes. But being bolder, I think, in the public sphere and probably doing this in an international way, cooperating, saying yes, devices have to be open. There are some basic principles we need to follow and steer industries towards is something we should aim for. And that's about incentives in the short term as well as probably more importantly now in the long term.
Fantastic. And thanks so much for being so impressively succinct, Michael. Julian, I just missed your hand as I called on Michael. So if you'd like to go first.
No, I think Michael made some excellent points about this. And I think part of the question is, how do we get the education levels high enough with politicians, with consumers, with everybody else to really think about this at an appropriate level? How do we set, I was talking about ethics and rules. We do need appropriate rules for some of this, but we have to have incentives throughout. And as Michael says, they have to be short-term and longer-term, because I think there is this challenge. We don't know exactly what's going to happen. We don't want to come up with rules which end up completely preventing us from being able to do things. If it ends up that inventions made in, sadly, just the UK, not just the EU, cannot do a whole set of things, but you buy it from anywhere else in the world, it can just go ahead. We haven't actually advanced things. One of the challenges with DeepMind Health is if you do medical research using AI on a non-UK population, it just means if you want to use it in the UK, you have to do more work and it's not going to be as good. You haven't necessarily advanced anybody. So I think one thing I would say overall is make sure that we actually get proper information, proper discussions, developments, like this conference, but with even more people around who really think about some of the realities as well as just the theory.
Important is this notion, or this paradigm we're in right now of short-termism, that while it's so important, I think, that we're all having conversations about the particular types of AI systems and tools that are directly affecting society right now, we also, of course, have to have not just the blue sky thinking, but we also do have to have in mind the approach that the path that we are setting down on now has huge implications on an individual level, on a collective level, on a national level, and on a global level as well. And at the same time, while, as Michael mentioned and Julian as well in the previous panel, while we can't anticipate all the developments and innovations that will take place, we can definitely look back, and yes, I'm biased. I will be the person now to advocate on behalf of the value of having the humanities and social sciences, and of course the lawyers, involved in these conversations, because while AI and its different manifestations going forward will bring new challenges and new systems that none of us could anticipate in the next 10 to 20 years, at the same time, a lot of the same regulatory and ethical problems that we had generations ago will still be there. They will go forward with us. We're not going to escape them as a society. The issues of inequality and issues of due process. And I think, when I mentioned it over the past few days, but in terms of corporate responsibility and the challenge of self-regulation, the thalidomide case study is one that always hangs over us all, I think. People questioned whether Cambridge Analytica was that moment, or people in the public sector area of scholarship and commentary wondered whether the Snowden revelations was that moment, or the Assange leaks, for instance, in terms of mass sharing of data and the capacity for AI used by various governments. So hopefully by having these conversations, Jane, by having these events, through this scholarship, through this work, collectively as well, it's not just about the lawyers, the humanities and social sciences, just to reassure Julian and all the other scientists who did join us over the past 2 days, and the other disciplines that also presented their work. We'll only get there, we all do it together. And that's important for academia as well, in terms of reaching out to industry, and also in terms of reaching out to different cultural contexts, different ethics systems there, different approaches. This is a global issue, as 2020, I think, has taught us so well in terms of the other global challenges we've had to deal with this year. So thank you so much for joining over the past 2 days, and I hope you have a lovely weekend, and do stay in touch and join us for other events at the Centre in future.